Ooh. Good morning, good morning, good morning, good morning, people. What's up? What's up? The brief has been filed. You go, Jennifer Bonjean. It's been filed. Come on in. What a blessing, because I work remotely on Wednesday. And with that said, I'm going to go ahead and read this damn thing. Well, as much as I can before I start work. It's like 116 damn pages. Rightfully so. Yes, come on in, guys. Come on in. And your girl will read brief for defendant, appellate Robert Sylvester Kelly. It actually says, on appeal from the United States District Court for the Eastern District of New York, brief for defendant appellant Robert Sylvester Kelly. Come on in, y'all. Come the hell on in here. Good morning, everybody. The brief is in. The brief is in. Now, you know it has a table of contents and all that shit. You know I ain't reading all that shit, right? I'm getting straight to the meat and the damn potatoes, which is the statement of the jurisdiction. That's the beginning of the brief. Man, I'm so glad it happened while I'm working home, from home today. So I'm going to try to read as much as I can before I have to hit the clock. Okay. So it's still printing out. I'm going to wait for some more people to come in, guys, before I get started. So in the between time, give me 1 second. Document is still printing, but I do have a few pages that I can start with, so that's good. But I need to step away 1 second. I'm so sorry. Give me a sec. I'm back. Sorry about that. I know you guys are patiently waiting, but you know your girl not gonna keep you waiting. All right, what I got in here? Do we have enough to get started? If not, they can always catch it on the replay. That's what I like to say. Good morning. I am so happy that this damn brief is in, and she filed the shit on the day I work from home. I'm happy as hell about that. So, let's do this, man. This is case number 2214A1, United States Court of Appeals for the Second Circuit, United States of America, versus Robert Sylvester Kelly, a.k.a. R. Kelly all damn day long, on appeal from the United States District Court for the Eastern District of New York, brief for the defendant, appellant Robert Sylvester Kelly. Jennifer Bonjean and Ashley of the Bonjean Law Group. All right, guys, here we go. Statement of jurisdiction. A jury returned a verdict finding defendant guilty of all charges in the government's third superseding indictment on September 27, 2021, Then there's something in a bracket that's making reference to a footnote. DE 238. Defendant was sentenced to a term of 30 years imprisonment on June 29, 2022. Judgment was entered on June 30th, 2022. Another bracket, DE 319. A timely notice of appeal was filed on July 22nd, 2022. Another bracket, DE 321. After a subsequent restitution hearing on September 28, 2022, the district court entered a restitution order on November 8, 2022, bracket DE 344. Defendant filed an amended notice of appeal on November 22nd, 2022. Another bracket, DE 354. This must be exhibits or something. An amended judgment was entered on December 7, 2022. Another bracket, DE 357. On September 9, 2022, the district court judge entered an order directing the Bureau of Prisons to turn over monies it seized from defendants' inmate trust account to the clerk of the court, DE 330. Defendant filed a notice of appeal from the order on September 9, 2022, bracket DE 332. Can you guys hear me okay? Please let me know. I'm sorry. I done got all into the damn brief and didn't even realize if you guys could even hear me or not. Please let me know. Please let me know. Give me a thumbs up, guys, because I don't want to proceed if you guys you can't hear me. Oh, okay, good. Good. Okay. On September 9, 2022, the district judge entered an order directing the Bureau of Prisons to turn over okay, I said that part. I'm sorry. The United States Court of Appeals for the Second Circuit has jurisdiction over these matters pursuant to 28 USC section 1291. And at the bottom, here's a footnote. Cites to the district court docket will be as follows. DE number cites to the special appendix will be as follows. SPA, hashtag, cities, cites to the appendix would be as follows. Volume number, and then in parentheses the A. I guess this is the sample for the judge to see how to identify the documents that she's going to make reference to. So that's all that is. Cites to the sealed appendix would be as follows, and she's just giving the example. So that's nothing. I'm going to bypass that, okay? All right. Issues presented for review. Here we go. Come on, Jen. That's my girl. Wait a minute, guys. Come on, Jen. Whether this is issues presented for review. Number one, whether the government failed to prove defendant guilty of racketeering where the record is devoid of evidence of an enterprise comprised of members who shared a common illegal or fraudulent purpose and where the defendant and the alleged enterprise were indistinct. Number two, whether the government failed to prove defendant guilty of violating the Mann Act as to Jane. Whether the government failed to prove, number three, whether the government failed to prove defendant guilty of violating the Mann Act as to Faith. Whether New York Public Health Law Section 2307 is unconstitutionally vague, such that defendant's Mann Act convictions predicated on that law must be vacated. Whether defendant's Mann Act convictions predicated on a violation of California Health and Safety Code section 120290 must be vacated. Because the government charged defendant with a repealed version of the statute that was unconstitutionally vague. Number 6, whether the government failed to prove defendant guilty of forced labor of Juror and faith based on an isolated sex act that did not constitute labor or service, and that neither victim alleged was forced. Hell no, that heifer wasn't forced. Number 7, whether defendant was denied a fair and impartial jury where 4 of the seated jurors admitted that they prejudged the defendant's guilt, and trial counsel provided ineffective assistance of counsel when he failed to move to disqualify the patently unqualified jurors or otherwise conduct let me say that over. Let me go back. Whether defendant was denied a fair and impartial jury where 4 of the seated jurors admitted that they prejudged the defendant's guilt, and trial counsel provided ineffective assistance of counsel when he failed to move to disqualify the patently unqualified jurors or otherwise conduct a meaningful voir dire of prospective jurors. Number 8, the defendant was denied a fair trial where the government swamped the jury with excessive other bad act evidence, including testimony from 7 additional witnesses who detailed defendant's unusual and graphic sexual activities, his history of transmitting herpes to his sex partners, his abusive behavior toward his girlfriends, and both audio and video recordings of this conduct with women and men, some of whom never testified. Whether the district court's restitution award for Jane and Stephanie's herpes treatment was unsupported by the government evidence. Whether the district court lacked authority to order the BOP to turn over monies seized from defendant's trust fund account to the clerk of court for future restitution payments. Statement of case. The defendant, an intentionally renowned recording artist, was charged with leading a racketeer influenced and corrupt organization, in quotes, RICO enterprise between 1994 and 2018, comprised of individuals whose objective was to promote defendant's music and to recruit women and girls in illegal sexual activities with defendant, and to produce pornography and child pornography. Defendant was separately charged with various Mann Act violations stemming from conduct in 2015 related to Jane and 2018 related to Faith. And then it has the sections and, all that. I'm not even going to say that section shit because you guys, it's making reference to what you want the panel to look at. So I'm just going to read the damn brief. I'm sorry. All right. After a 6-week jury trial, defendant was convicted of all counts of the 3rd superseding indictment. He was later sentenced to 30 years imprisonment. Through new counsel, defendant filed extensive post-trial motions pursuant to federal rule criminal page 20. Oh, I said I wasn't going to read all that shit. That were denied by the district court in a 103-page memorandum decision and order. And that's all making reference. Defendant includes a concise statement of the case setting out the facts relevant to the issues raised in this brief, and also refers this court to the district court's detailed factual background presented in light most favorable to the government contained in this order. A, pretrial motions. Oh, here's a footnote down here. On September 14, 2022, defendant was convicted in the Northern District of Illinois with 3 counts of production of child pornography and 3 enticement counts. He was acquitted of obstruction of justice, receiving child pornography, and 2 enticement counts. And she states a case site. Defendant was sentenced to 20 years imprisonment, ordered to run concurrent to the sentence in the instant case, with the exception of 1 year, which was ordered to run consecutive. All charges brought by the state of Illinois were subsequently dismissed. Defendant still has 1 pending criminal case in the state of Minnesota. Damn, which case is that one? I'm stuck on that one. He must have had 2 there. Defendant unsuccessfully moved to dismiss the RICO count pre-trial, arguing that the government failed to sufficiently plead a RICO enterprise. Defendant also moved to dismiss as unconstitutional those Mann Act charges premised on a violation of New York Public Health Law Section 2307. The district court denied the motion in a written order. On July 23, 2021, the government filed a 55-page motion seeking to admit extensive prior bad act evidence. On July 30th, 2021, defense counsel filed a written objection to the government's motion and filed a supplemental response on August 6, 2021. The district court issued a ruling from the bench, followed by a written order largely granting the government's motion. Throughout trial, defense counsel asked the court to reconsider some of its rulings regarding the admission of other bad act evidence, mostly unsuccessfully. B, jury selection. Because of extraordinary pretrial publicity, the district court directed the parties to submit a joint proposed jury questionnaire to be completed by prospective jurors. The parties reviewed the questionnaires to determine whether they could agree to the dismissal of some jurors for cause. The district court conducted an oral voir dire as to the remaining prospective jurors, affording the parties the opportunity to submit additional questions to probe their qualifications to serve as jurors. Numerous seated jurors were either familiar with accusations that defendant had a history of sexually abusing underage girls, had previously faced legal problems, and or had seen the highly unflattering docuseries Surviving R. Kelly. And there's a footnote there. Surviving R. Kelly was a Lifetime docuseries that details sexual abuse allegations against the defendant. It aired over 3 nights from January 3rd to January 5th, 2019. In this premiere episode, it was Lifetime's highest rated program in more than 2 years, with 2 million total viewers. And she put the she put a link in there for the judges to check that site out. Okay, let me go back up here, in which several government witnesses had appeared. Defense counsel did not move to disqualify jurors who admitted they had prejudged defendant's guilt or had gathered knowledge about the case from other sources. Defendant was largely excluded from the voir dire process. C, complainant's testimony. The third superseding indictment charged defendant with various racketeering acts related to sexual misconduct committed against 6 women, inter alia Geronda, Jane Doe number 4, Jane Doe number 5, and Faith, Jane Doe number 6. Number 1, Geronda. In 2008, Geronda was a super fan of the defendant and met him as she walked alongside him as he left court. She told him she was a fan And she making reference to the volume. Okay. She was a fan. In May 2009, Geronda and her friend received an invitation to a party at defendant's home by one of defendant's employees. Geronda spoke with defendant at the party and exchanged phone numbers. She falsely told him she was 19. A few days later, the defendant invited Geronda back to his house, where they engaged in sexual contact. According to Geronda, she felt uncomfortable and privately confessed to the defendant that she was actually 16 years old. Defendant told her to continue to tell everyone that she was 19. Geronda did not testify that she told anyone other than defendant that she was 16. Geronda continued visiting defendant and having sex with him for approximately 8 months. I thought he didn't have sex with her. Okay. No shit. On January 23rd, 2010, Geronda testified that defendant slapped her and choked her for disrespecting him. Defendant went into the VIP room with Geronda, where he instructed her to perform oral sex on him, which she did. Geronda left defendant's studio after this incident and did not return. Thereafter, she sued the defendant. Number 2, Jane. Jane and her parents attended one of defendant's concerts in Orlando, Florida in April 2015. She was 17 years old. Jane claimed that she made eye contact and connected with defendant while he was performing and danced on the stage during the performance. Someone provided Jane with defendant's phone number after the show. Jane attempted to call the number but could not reach the defendant. Jane's mother began texting the defendant, pretending to be Jane, over the course of 2 days. Jane eventually spoke to defendant and falsely told him she was 18 years of age. Jane met the defendant at his hotel room in Orlando, where they engaged in sexual contact. At one point, the police arrived and Jane reassured the defendant she was 18. After checking Jane's identification and confirming that she was 18, the police left. Thereafter, defendant invited Jane to meet him in Los Angeles, where he was performing. With her mother's consent and encouragement, Jane met defendant in California and traveled with him while he was touring. After his performance in Stockton, they had sexual intercourse for the first time. Jane moved to Chicago the summer of 2015 to stay with defendant, but when defendant learned she was only 17 years old, he sent her home to Florida. So that did happen. With the consent of parents, Jane returned to Chicago to live with defendant. All right, it's hot in here. Shit, I had to turn this fan on. Okay, well, I'll leave off it. To live with defendant. In September and October 2015, she toured with him again in the state of California. Jane turned 18 in December of 2015. Jane and defendant continued a relationship for 5 years. Defendant had other live-in girlfriends. Jane characterized the relationship as abusive at times and detailed that defendant had many rules and would punish her and his other girlfriends with spankings if they broke the rules. That shit, whatever. Faith. Number 3, Faith. Faith met the defendant in March 2017 at a concert in San Diego, Texas, when she was 19 years old. She and her sister were invited to an after party where she met the defendant and gave her his phone number. Faith and defendant began texting regularly. Defendant and Faith met each other in person 5 times and had sexual encounters during those occasions. Defendant arranged for Faith to travel to New York on 2 occasions, in May and in February of 2018, where they engaged in sexual activity. Faith also traveled to Los Angeles 1 occasion in January 2018, where, according to Faith, she saw a gun in his studio that unnerved her. These fake ass, man. At the defendant's direction, the defendant performed oral sex on the defendant. D. Defendant's former employees. The government presented testimony from roughly 8 former employees of the defendant. None of these individuals were charged as members of the enterprise. Number 1, Demetrius Smith, friend and personal assistant from 1984 to 1994. Smith met defendant as a teenager when he was still attending high school and singing in subways in the mid-'80s. Smith was first a friend and mentor to the defendant and then began working as his personal assistant when defendant received his first record deal in 1988 or 1989. Smith worked off and on for defendant as a personal assistant until 1994. Smith's responsibilities included assisting the defendant in things he needed and with scheduling. Smith testified that defendant met Aaliyah through his manager, Barry Hankerson, who was Aaliyah's uncle. Smith testified that from his perspective, their relationship was strictly about music and that he never saw defendant take Aaliyah out by herself. Smith did concede there were short periods of time when defendant might be alone with Aaliyah. There were times when he thought defendant and Aaliyah were overly playful or too friendly, and he asked defendant if he was messing with Aaliyah, to which defendant always responded no. Smith raised those concerns a few times, but only learned that the relationship was more than platonic in 1994, when it was believed that Aaliyah might be pregnant. Number 2, Anthony Navarro, runner and sound engineer. Oh, shit. I'm sorry, wait a minute. From 2007 to 2009. Anthony Navarro worked as a sound engineer in defendant's studio for 2.5 years. Navarro understood it was entry-level position. Damn, I think this should be this is a damn typo. God damn it. I think she's saying Navarro understood it was entry-level and position, and I'm going to say and, God damn it, would include such duties as cleaning, doing food runs, and driving guests around. Navarro testified that numerous people came through the studio, including different girlfriends of the defendant. One of his responsibilities was to drive the girlfriends where they needed to go. He was instructed not to speak with defendant's guests. Navarro explained that defendant's guests were generally required to ask permission if they wanted things or wanted to order food, and they were not permitted to wander the studio or defendant's home unaccompanied. Sometimes these guests would stay at the studio for an extended time, but could leave if they wanted to. Navarro did not know the details of why any female guests visited defendant. Navarro never picked up female guests who appeared to be underage. They appeared to be around his age, in their early 20s. Navarro had never seen defendant engaging in sexual activity in his home or his studio. Navarro went on tour with the defendant and observed that invites would be distributed to attendees for after parties. Sometimes defendant's phone number would be on the invites, At times, he would see defendant's phone number distributed to people at the mall or at a restaurant. Navarro never saw underage girls backstage. Navarro recalled that identifications were checked before people could go backstage, but he could not recall whether people had to be 18 or 21. Number three, Tom Arnold, runner, studio manager from 98 to 2011. Tom Arnold worked for defendant from 1998 to 2011. He started as a runner and eventually became his studio manager and road manager. One of Arnold's responsibilities working for defendant was to provide transportation to his guests, which could include men with whom defendant played baseball, a musician, and his female guests. If defendant wanted Arnold to transport a guest somewhere, defendant would tell him directly, or someone with defendant would make the request. Arnold testified that the protocol for driving guests from one location to another was to open the door for them, turn the rear view mirror up, and turn the radio on to a reasonable volume. Arnold understood that turning the rear view mirror up was to avoid eye contact with defendant's female guests and to ensure their privacy. Guests at the studio were required to were required to sign confidentiality agreements that prohibited guests from recording or taking photographs. Staff would either take Polaroid photos of guests or copy their identifications to confirm the identity of the person signing the confidentiality agreement. The policy of having studio guests sign confidential agreements originated with defendant's business manager and lawyer. Arnold generally had no interactions with defendant's female guests. If a guest in the studio was hungry, they would call the front desk and Arnold would arrange to get them food with petty cash that was at the reception area. If a guest wanted to move from one location in the studio to another, Arnold would get permission to escort the guest. If a guest wanted to speak with the defendant, Arnold would relay the message to defendant. Arnold explained that generally guests would not be able to roam defendant's studio and home freely, but ask for permission to go from one part of the studio to another. Arnold testified that there were instances where he would provide defendant's phone number to a woman, not normally in a concert setting, but an after party or a club, or possibly a mall. There were also other members of the entourage who would give women defendant's phone number. Underage people were not permitted backstage, and identifications were checked to ensure that. Arnold did not testify that he provided defendant's phone number to any woman. That should have said, oh shit, what was she trying to say? Arnold did not testify that he provided defendant's phone number to any women underage. Arnold testified that he sometimes arranged travel for defendant's female guests until they began using a professional travel company. Arnold would obtain the guests' identifications to arrange their travel. Arnold did not testify that he ever booked travel for an underage female guest. Number 4, Suzette and Alicet. Damn, I don't know that girl's name. These are the Mayweather women. Suzette and Alicet Mayweather. Personal assistants in 2016. Suzette and Alicet worked as I don't know if I'm pronouncing their names correctly, guys, but I know you guys know who they are. Worked as personal assistants for the defendant. Suzette worked for the defendant between October 2015 and February 2017. Alicet worked for the defendant between late 2015 to 2016. Their job responsibilities were to tend to anything he needed, running errands, grocery shopping, taking care of laundry, arranging accommodations for guests, female and male, coming into town, and booking. Let me get the rest of the pages, guys. That's printing. Okay. Oh, shit. I'm watching the clock because I'm going to have to log in. I stopped and put, okay. And booking airfare. Suzette and Alizette testified that defendant had several live-in girlfriends during this period of time. They testified that defendant was controlling of his girlfriends, expected them to follow certain rules, dress down in baggy clothes, and suspected he slapped or spanked them previously. On a couple of occasions, the sisters expressed concern amongst themselves about defendant's mistreatment of Jane. The sisters denied that they took any action at any time to assist defendant in procuring girls or women. Number 5, Diane Copeland, personal assistant, executive assistant intermittently from 2005 to 2018. Copeland began working for the defendant in 2004 or 2005 as a personal assistant and worked off and on for him until 2018. Her responsibilities were largely household in the beginning, tending to housekeeping and nannies, and making sure they were paid. Later on, Copeland would do administrative jobs like answering the phones, maintaining defendant's schedule, and tending to defendant's guests, which could be anyone from a record label executive to a personal guest. Copeland would make hotel and travel arrangements for the defendant, his entourage, and his girlfriends. Copeland would sometimes carry defendant's backpack, but she never went through it. She did see an iPad in one of his backpacks once. During his last stint of employment with, during her last stint of employment with the defendant, one of Copeland's responsibilities was to help him get control of his finances. Defendant had difficulties reading and writing. He had no control over his bank accounts, did not even know his Social Security number, and did not know where his royalties were going. Defendant instituted rules for guests on his property, namely to knock before entering a room and not to roam around the property unsupervised. These rules applied to everyone and were actually initiated by his wife when she lived on the property. Copeland acknowledged that defendant's girlfriends also followed defendant's rules to wear baggy clothes and not to interact with other men in public. Defendant had girlfriends who stayed at his properties, sometimes for extended periods of time. Some girlfriends lived in defendant's home while others did not. They were free to leave if they wanted to. Copeland never attempted to stop any of defendant's girlfriends from leaving his property. Defendant never asked Copeland to recruit women for him, nor did she ever ask him, any other employee, to recruit women for him. Copeland never saw defendant attempt to prevent any woman from leaving his home. She never saw defendant lock any of his girlfriends in a room. And he never asked her to confine any of his girlfriends. Defendant's girlfriends had constant access to food and assistance to help them with anything they wanted. Number 6, Nicole Williams, intern runner in 2003. Williams worked for the defendant for a year in 2003 when he was 19 years old. He described the environment as a hostile work environment and was disappointed that was not able to use the audio equipment. Different types of people visited defendant at the studio, ranging from professional artists, musicians, actors with whom he was doing projects, personal trainer, sometimes his entourage, and female guests. Williams noticed that defendant's female guests at the studio were young. Williams was instructed not to interact with the female guests. Number 7, Cheryl Mack, executive assistant from 2014 to 2015. Mack met defendant in 2005 when she was working as a talent manager in the industry. She connected with defendant in 2013 through another record executive and began working as defendant's executive assistant in 2014. Damn, Jennifer, we got another damn typo in here. Mack managed defendant's calendar and worked on projects with him. She also arranged travel for his guests and entourage. Mack will arrange travel as requested by the defendant and use the company credit card to book necessary reservations. She used a company known as Preferred Travel to make most reservations. Mack was prohibited from socializing with defendant's guests. Mack received a text message from Jane in April of 2015 asking her to book travel arrangements to California for Jane, which Mack did. Mack later met Jane in the lobby of the Mandalay Bay Hotel in Las Vegas, where she was checking into her hotel room. Mack also saw Jane in Kelly's dressing room at a venue in Connecticut where he was performing. She was there with several other individuals, but eventually she left when Kelly began massaging Jane's leg because it made her feel uncomfortable. Mack quit the following day. This shit sounds crazy as hell. E, other bad act evidence. Over the defendant's objections, the district court permitted the government to admit testimony about defendant's uncharged sexual misbehavior with at least 8 other individuals, including testimony from Angela, Addie, Kate, Alexis, Lewis, Alex, and Anna. The district court's order details the testimony of these other bad act witnesses. The district court further permitted testimony from numerous witnesses and through medical documents about defendant's history, contracting sexually transmitted diseases, including herpes, and his alleged transmission of herpes to women, other than any complainants. The district court allowed the introduction of evidence related to defendant's alleged mistreatment of employees, including docketing their pay for violating his policies and rules. The district court permitted the jury to hear audio recordings of the defendant's alleged verbal and physical assaults of his girlfriends unrelated to the charged offenses. The district court further permitted several video recordings of graphic sexual encounters, including 1, sexual conduct between Alex, Dominique, and the defendant. Defendant spanking a naked Anna and calling her insulting names. Anna spreading feces. Oh my God. Anna spreading feces on her own naked body. Defendant filed a motion for a new trial based inter alia on the court's admission of excessive, cumulative, and highly prejudicial other bad act evidence. The district court denied the motion. F, verdict. Why would that girl? Oh, Lord, but that's her shit, literally. F, verdicts and sentencing. The jury returned a verdict finding defendant guilty on all counts of the indictment. The jury acquitted the defendant of racketeering accounts in connection to claims made by Sonia. On June 29, 2022, the district court sentenced defendant to a term of 30 years imprisonment and imposed court fines and costs. The court deferred a ruling on restitution. G. Seize of defendant's trust fund account. Oh, fuck. Goddamn, another damn typo. I don't know what, maybe it's 2022. It got to be 2022. Oh my God. On August 4, I want to say 2022. It has to be that. At the government's direction, the Bureau of Prison, BOP, confiscated $27,827.24 of money from the defendant's trust account. The government then filed a motion with the district court for an order directing the BOP to deposit the funds into the clerk of court. Defendant objected to the seizure and any turnover order on the grounds that the BOP impermissibly confiscated the funds and the government lacked authority to seize the money where no fault was entered. No restraining order was in place, and restitution had not even been ordered in the case. The district court allowed the government's motion. That's some shit. H, restitution. The district court conducted a restitution hearing and awarded Jane, this fucking fraud, $281,168.18 for medication, Valtrex, to treat genital herpes for the rest of her life. That a bitch. The district court also ordered defendant to pay Stephanie $78,981.72 in restitution, primarily to compensate her for medication to treat genital herpes that Stephanie claimed was transmitted to her by the defendant. Right on, Jennifer. I caught that, claimed. Defendant objected to the court's calculation of these amounts, where the government offered no evidence that Jane and Stephanie were receiving suppressive treatment with Valtrex, the brand name prescription for valacyclovir. I don't know if I'm pronouncing that correctly. And offered no explanation for why compensation should include the monthly cost of Valtrex, which was nearly 40 times more expensive than valacyclovir, the generic version of drugs. Defendant's objections were overruled. Summary of argument. And she cites a case, Fitzgerald versus Chrysler. Chief Judge Posner cautioned that where a statute are broadly worded in order to prevent loopholes from being drilled in it by ingenious lawyers, there is a danger of it being applied to situations absurdly remote from the concerns of the statute's framers. Such is the case here, where the government misused both the racketeer influence and corrupt organization statute, RICO, and the Mann Act in a manner never previously conceived or carried out. Galvanized by an influential social movement determined to punish centuries of male misbehavior through symbolic prosecutions of high-profile men. The government brought a RICO prosecution against the defendant that was absurdly remote from the drafter's intent. Stretching the liberal construction clause well beyond the intent of Congress, the government constructed a RICO theory designed not to effectuate the purpose of the RICO statute, but to prosecute the defendant for alleged misdeeds going back decades without pesky statutes of limitation obstacles. In the end, the government failed to prove the offense of racketeering, where evidence of a RICO enterprise was non-existent. The government's evidence failed to show a collective of individuals who shared common purpose other than to promote defendant's music. At best, the government's demonstrated that the defendant used unwitting, low-level employees to carry out anodyne tasks that arguably facilitated his sexual needs, but had no knowledge, intent, or objective to promote his illegal sexual activities. Guys, I'm going to pause right there because I need to sign into my job, and I'm going to continue on. Give me 1 second, please. Give me 1 second, but I got to sign in. This will not take long. But your girl, she's still working even though she's at home. Give me 1 second. Let me sign in. Let them know I'm here. I'm here. I'm here. Oh, shit. Oh, damn. I'm in. I'm in. I was hoping the damn shit didn't work. But I'm in here. All right. Give me 1 second. Oh, shit. Where's the damn... 1 second, guys. I'll be back. But this is something your girl has to do. That damn thing not coming on. Oh, shit. This damn thing is locked up. Ain't this some shit? Damn. I just got on. Sorry, guys. Give me 1 second. Well, I'll be damned. Oh, shit. They might not even let me get back in this damn thing. I'm coming. Oh, okay. All right. Get this shit open. All right. Sister girl in business. Just got to check some shit out. Damn. Okay. All right. I'm all logged in, so now I can get back. So where the hell? All right. So I'm going to read that paragraph over. Common purpose other than to promote defendant's music. At best, the government demonstrated that the defendant used unwitting low-level employees to carry out anodyne tasks that arguably facilitated his sexual needs, but who had no knowledge, intent, or objective to promote his illegal sexual activities. Adding to its long history of celebrity Mann Act prosecutions, the government charged defendant with violating federal law by arranging Jane and Faith's travel to other states, California and New York, to attend his concerts with the purpose of violating public health laws, namely by exposing them to herpes during sexual intercourse. Neither Jane nor Faith were actually infected with herpes during these travels. Because the government could not, as a matter of law, prove that a significant and motivating factor for defendants' transportation of Jane and Faith was to expose them herpes in violation of state public health laws, the convictions cannot be sustained. You know that's right, Jennifer. There are more problems with the government's creative charging approach. For one, the California Public Health Code that the government contends defendant violated, California Health Safety Code Section 120290, was repealed by the California legislature and was inoperative at the time of defendant's prosecution. No shit. Further, both California Health Care Safety Code Section 120290 as charged, and New York Public Health Law Section 2307, which intend to criminalize exposure to communicable diseases, are unconstitutionally vague, where a person of ordinary intelligence would have no notice of what the statute prohibits. And as the case so aptly demonstrates, this statute encouraged arbitrary and discriminatory enforcement. Defendant may be the only person in history who has been charged with violating the federal Mann Act based on alleged misdemeanor infractions of state public health laws. He is decidedly the only person who has been charged with violating these laws without having actually infected the alleged victims with an infectious disease. The government's proof problems extend to its forced labor charges, evincing a clear intent to make federal law coextensive with state law. The government charged defendant with violating the forced labor statute because isolated occasions. He instructed or directed Geronda and Faith to perform an act of oral sex on him, where an isolated sex act is neither a labor or service, and neither women testified that defendant forced the sex act. The government failed to prove violations of federal forced labor laws. That damn government was something else with they halfway slick ass. Sufficiency of the evidence aside, defendant is entitled to a new trial where the record shows that at a minimum, 4 of the seated jurors, 3, 4, 5, and 12, were not qualified to serve. 2 of them had watched the inflammatory tabloid docuseries Surviving R. Kelly. Trial counsel's performance was objectively unreasonable when he failed to move to disqualify patently unqualified jurors and failed to conduct any meaningful voir dire of prospective jurors who expressed their prejudgment of the case. Defendant was prejudiced by his counsel's his counsel's standard performance, where it resulted in the seating of at least 4 jurors who were actually biased and could not act with impartiality. There is more. Defendant's trial was engulfed by irrelevant and excessive bad character evidence that added little to jurors' assessment of whether defendant committed the charged offenses. Indeed, the 6-week trial was comprised overwhelmingly of uncharged bad act evidence that served no legitimate evidentiary purpose. With the court's blessing, the government smuggled in a mass of repugnant conduct under the guise with the evidence demonstrated the means and method of a non-existent enterprise. The case was not about an enterprise. It was about the conduct of one man who the government sought to punish for his alleged history of mistreating women. As such, the mountain of bad act evidence offered in this prosecution was nothing more than inadmissible propensity evidence, because defendant was forced to defend against dozens of uncharged claims of abusive and sexual misbehavior. Much of it lawful, albeit unpalatable for some. Defendant was stripped of the presumption of innocence and denied a fair trial. You know that's right. Lastly, the district court abused its discretion in granting Jane nearly $300,000 in restitution and $50,000 for a lifetime supply of Valtrex for herpes treatment. Where the government failed to establish that the women were infected with herpes as a result of any of the charged conduct, that either of them are treated with suppressive regimen of Valtrex and or actually treat with Valtrex rather than valacyclovir, the generic version of Valtrex, which is a fraction of the cost of Valtrex. The government failed to offer sufficient evidence to justify the exceptional restitution award. In short, the district court abused the purpose of restitution statute and granted Jane a windfall reward for costs she has never incurred or will incur, seemingly to punish the defendant. In its final push to punish the defendant, the district court abused its discretion when it ordered the Bureau of Prisons to turn over $27,000 of seized money from defendant's inmate's trust account for use against future restitution award, without any showing that defendant had defaulted or failed to live up to his payment obligations. Defendant's convictions must be reversed, or in the alternative, a new trial must be granted. I do not want a new trial, guys. I do not. Okay. I don't know how she's doing this. The government failed to prove defendant guilty of racketeering, where the record is devoid of evidence of an enterprise comprised of members who shared a common illegal or fraudulent purpose, and where the defendant and the alleged enterprise were indistinct. Ignoring the indistinct economic legislative history of the RICO statute, the government brought a RICO prosecution against defendant, not to remedy widespread criminal activity of an enterprise, but to punish one man who alleged crimes could no longer be prosecuted by state and local agencies under the guise of the liberal construction clause. The government manufactured an ill-fitting RICO theory that was unsupported by the evidence. To be sure, prosecutors have used RICO in a wide variety of circumstances, but the liberal construction clause is not an invitation to apply RICO to new purposes that Congress never intended. Go on, Jennifer. In this rush to indict public enemy number one of the hashtag Me Too movement, the government stretched the statute beyond its limits, applying it under circumstances leaves removed from the statute purpose. Accordingly, when the time came to prove its RICO charge, the government failed at the fundamental task of establishing an enterprise. To convict a defendant of racketeering, the government must prove at a minimum the existence of an enterprise and a related pattern of racketeering activity. Then she's got some case sites there. Viewing the evidence in light of most favorable to the government and drawing all inferences in its favor, this court must vacate defendant's conviction of racketeering where the government's evidence of a RICO enterprise was insufficient. I'm sorry, guys. I got to check these damn emails and shit. I'm on the clock now. A, general legal principles. An enterprise includes any individual, partnership, corporation, association, or other legal entity, and any union or group of individuals associated, in fact, although not a legal entity. The United States Supreme Court has defined a RICO enterprise as a group of persons associated together for a common purpose of engaging in a course of conduct. And then she, of course, have a case site. An enterprise is demonstrated by evidence of an ongoing organization, formal or informal, and by evidence that various associates function as a continuing unit. For an association of individuals to constitute an enterprise, the individuals must share a common purpose to engage in a particular fraudulent cause of conduct and work together to achieve such purposes. The enterprise's purpose must be common to all of its members. All right, guys, damn. I'm sorry, I got to send a damn email. I'm sorry, you got to bear with me. I'm trying, but I'm trying to handle two tasks at the same time. Let me send this shit and get them off my back. Do this shit. I'm so glad we don't have our meeting. I hope he don't change this shit. We don't have our telephone conference until 11. So that's awesome. All right, let me email this shit. Good morning, everyone. All of you that came in after I already spoke to the ones that arrived. Welcome, welcome, welcome. Thank you for coming to hang with me early this morning. All right. Take this job and I'll come back. Morning. Days reminders. All right. Get that shit out the way. All right. Got that shit done. All right. Okay. All right. Let me read this paragraph over. Oh, no, I just finished that one. Okay. Here we go. The enterprise is neither the individual defendant nor the pattern of racketeering activity. Rather, it is an entity separate and apart from the pattern of activity in which it engaged and must be alleged and proved separately. However, there must be a nexus between the enterprise and the racketeering activity that is being conducted. Against this legal backdrop, and taking the evidence in the light most favorable to the government failed to prove a RICO enterprise. Assuming arguendo, the government's evidence was sufficient to establish that the defendant committed various sex offenses between 1994 and 2018. Its evidence did not show that those offenses were committed as part of an enterprise. Specifically, the government's failure to demonstrate a fraudulent or illegal common purpose of the enterprise distinct from the defendant or his racketeering activities was fatal to its RICO theory, notwithstanding the jury's verdict. B, no common purpose to engage in a fraudulent or illegal course of action. In its third superseding indictment, the government alleged inter alia that the defendant, individuals he employed, and members of his entourage constituted a group of individuals associated, in fact, who functioned as a continuing unit for the common purpose of promoting defendant's music and brand and to recruit women and girls in illegal sexual activity with defendant and to produce pornography and child pornography. I just hate when they put that child shit in there. That really just, it just really pisses me off. Defendant does not dispute that during his 25-year recording career, he maintained a production company that employed dozens of people. Defendant's business was no different than other businesses, both in the music industry and elsewhere. Typical of a hugely famous recording artist, defendant employed managers, accountants, engineers, security personnel, drivers, runners, and personal assistants. Defendant concedes that people on his payroll or in his so-called entourage generally shared a common purpose of promoting his music. But the evidence failed to show that his employees shared a common purpose to recruit women and girls to engage in illegal sexual activity with the defendant in the production of child pornography. Whatever. Out of the gate, this RICO prosecution was suspect where the only person named in the indictment was defendant. While the government is under no obligation to indict every member of a RICO enterprise, if the government lacks evidence to indict any other member of an alleged enterprise, it is a good sign that no RICO enterprise exists. Go on, Jennifer. The government banned about buzzwords of a legitimate RICO prosecution, quick to label everyone and anyone in defendant's orbit as part of his inner circle, but came up short on actual evidence of an inner circle of people who carried out the purpose of the so-called enterprise. Government witnesses, only 8 former employees testified. None offered testimony establishing personal knowledge of defendants' purported illegal sexual conduct, let alone knowing facilitation of it. Despite repeated references, what was that? Okay. Despite repeated references to defendants' inner circle, which connotes a small group of individuals close to the leader of a group, the government's enterprise evidence came largely from a handful of low-level employees. These employees were consistent in their account of working for defendant. They largely just followed rules, some arguably strange, but not inherently illegal. They were not privy to defendant's sex life or the details of his relationships. Most importantly, they never agreed to assist or help the defendant engage in illegal sexual conduct of any kind. Quite the opposite. For example, personal assistants Suzette and Alicette expressed concern about how defendant treated some of his live-in girlfriends, and both women worked for the defendant for short periods of time. Cheryl Mack quit her job the very next day after meeting Jane and observing her interactions with the defendant. The district court makes much of testimony that employees would sometimes pass defendant's phone number along to women. Not a single employee testified that they ever knowingly provided defendant's phone number to a minor or were asked. The record fails to show that there was an expectation to recruit underage girls or that any employee received a benefit for doing so. Indeed, both Anthony Navarro and Tom Arnold denied ever providing defendant's phone number to underage girls or driving any woman who appeared to be minors. In fact, the government's evidence reveals that employees were prohibited from interacting with defendant's girlfriend or talking about his relationship with them. Geronda testified that defendant instructed her to continue to tell people that she was 19 after he learned she was 16. In short, the record is devoid of evidence that the members of the enterprise acted with common objective of ensuring that defendant engaged in illegal sexual activity. I'm sorry, guys. You know I'm working. I got to check this shit. What the hell going on? I just hope he don't change this damn time. I'm sick of his ass. Let's see. Rather, the evidence showed that whatever illegal sexual activity in which the defendant engaged was concealed from his employees, and he took measures to keep his personal sexual life secret. That some employees witnessed concerning or odd conduct by the defendant is not the same as sharing a common purpose to promote his illegal sexual conduct. Almost conceding that evidence of an enterprise was insufficient, the district court held that the government was not required to show a common purpose of illegal or fraudulent activity so long as the persons associated, in fact, share any common purpose, including the entirely legal purpose of promoting defendant's music and brand. Not so. As held in Satanwood, for an association of individuals to constitute an enterprise, the individuals must share a common purpose to engage in a particular fraudulent cause of conduct and work together to achieve such purposes. Then they have a case site there of the Satanwood. Okay. So it's basically saying those cases, all generally holding that to constitute an enterprise, the association of individuals must share a common purpose to engage in a fraudulent or illegal course of conduct. Thus, for the government to prove an enterprise here, it was required to prove that defendant and all members of so-called association, in fact, enterprise, came together with the common purpose of recruiting women and girls to engage in illegal sexual activity, not merely the broader purpose of promoting defendant's music or brand. In an instructive case, and she's talking about the Moss versus the BMO Harris Bank case, the plaintiff brought a putative class action against First Premier Bank, alleging RICO violations. The plaintiff charged that FPB, a formal legal entity, belonged to the Automated Clearinghouse Network, a payment processing system that processed unlawful ACH transactions on behalf of payday lenders. The plaintiff argued, inter alia, that the ACH network constituted an enterprise consisting of originators, various depository financial institutions that received ACH transaction instructions, ACH operators, and third-party service providers, all of which shared common lawful purpose of facilitating batch processing of electronic payments for and between participating depository financial institutions. The court concluded that the ACH network described by plaintiff did not constitute an enterprise for RICO purposes because it did not share a common purpose to engage in a particular fraudulent course of conduct and work together to achieve such purposes, which was fatal to his claim. Emphasis in the original. And she put the cites again. Affirming dismissal of association, in fact, RICO claim where the amended complaint admitted that certain participants in the purported enterprise were not aware of the deceptive practices at issue. Then she cites the First National Bank case. Critically, the Moss Court expressly rejected the plaintiff's enterprise theory, finding it implausible that all of the institutions that allegedly made up the enterprise possess the unlawful intent required to transform that cooperative into an association, in fact, enterprise for RICO purposes. There's she cites another case here. It's the look like Intel versus the Alley Financial Company, dismissing RICO claims that allege that defendants used mortgage electronic registration system to conceal unlawful mortgage transfers because plaintiff failed to show coordinated activity to jointly achieve a common fraudulent purpose. Emphasis in the original. The Moss Court observed that at best, the defendant used a legitimate network to advance its own illegitimate business interests, and that the alleged illicit ACH transactions did not render the ACH network a RICO enterprise, absent a common purpose among other network participants to violate RICO. The Moss Court's logic applies with full force here. The government's evidence showed, at best, that defendant used his role within his legitimate music-driven collective to participate in private sexual misconduct. As in Moss, defendant's use of his otherwise legitimate music business to advance his allegedly illegitimate sexual needs does not render defendant's business organization a RICO enterprise, absent a common purpose among his associates, violate RICO. That defendant's employees shared an abstract purpose of promoting defendant's music and brand does not satisfy the common purpose requirement, since there still must exist a nexus between the objective of the enterprise and the racketeering activity. What is this? Indelecto. Wait a minute. Indelecto. It is plain that for establishment of a RICO violation, there must be some kind of relationship between the acts and the enterprise, for each of these substantive RICO subsections prohibits a specific type of interplay between a pattern of racketeering activity and the enterprise. See also scenarios. That's another case she's citing. Holding that an abstract common purpose, such as a general shared interest in making money, will not suffice to establish an enterprise. Rather, where their participants' ultimate purpose is to make money for themselves, a RICO plaintiff must plausibly allege that the participants shared the purpose of enriching themselves through a particular criminal course of conduct. Observing that the common purpose of making money would not be sufficient to find an association. Okay, I have to check my emails. You know I'm working, guys. I'm working. Common purpose of making money would not be sufficient to find an association, in fact, enterprise between Spirit Airlines and outside vendors who merely provided anodyne services. Then she cites another case here, Sharam versus Mercy. In its order, the district court claims that Satinwood is at odds with Turkett because Turkett mentioned nothing about a fraudulent course of conduct, holding only that the individuals in an enterprise must share a common purpose to engage in a course of conduct. A closer look at Turkett strongly suggests that the Supreme Court presumed illegality in the course of conduct to which it referred. The question presented to the court in Turkett did not involve a deep dive into the course of conduct language, but addressed whether an enterprise encompasses both legitimate and illegitimate enterprises or is limited in application to the former. Turkett. That case site again. Rejected the argument that an entirely illegal organization was outside the purview of the RICO statute or inconsistent with the statute's purpose. The court wrote, on the contrary, these statements of purpose are in full accord with the proposition that RICO is equally applicable to a criminal enterprise that has no legitimate dimension or has yet to acquire one. During its discussion, the Turkett assumes a RICO enterprise would have some criminal objective. The court compared those associations, in fact, that were entirely criminal in nature with those that were mixed bag of criminality and legitimacy. Turkett never suggested that an enterprise could be established by individuals engaging in a course of conduct with an entirely legal purpose that was unrelated to the alleged racketeering acts of one person in the enterprise. The RICO statute was never intended to remedy criminal conduct of individuals who carried out their misdeeds through use of routine services by their unwitting personal assistants. Under the government and the district court's logic, an entirely rogue actor working in an otherwise entirely legal organization could be prosecuted under RICO for merely duping his assistants or associates into facilitating his misdeeds with mundane tasks. One could think of countless duties asked of unwitting personal assistants, such as making hotel reservations, calling an Uber, throwing out a bag of garbage, or delivering a message that could facilitate a crime perpetuated by an individual working to the context of a business. That does not a RICO enterprise make. Oh damn, I don't know what she was trying to put there. That's something wrong with that sentence. That does not, I don't know. That does not a RICO enterprise make. I don't know what the hell was. I don't know what that's got. Oh, B. Defendant and the enterprise are not distinct. Relatedly, the government's evidence of a RICO enterprise was insufficient because defendant is indistinct from the enterprise. For section 1962 purposes, C purposes. The person charged with a RICO violation and the alleged enterprise must be separate and distinct from one another. Cedric versus Kushner, that's a case site. I'm not doing them case sites. Holding that one must and prove the existence of two distinct entities. One, a person, and two, an enterprise. That is not simply the same person referred to by a different name. This requirement flows from the statutory mandate that a person who engaged in a pattern of racketeering activity must be employed by or associated with the enterprise. Then she cites the Satinwood case again, and the Riverwoods, and the Bennett, and the Brandon. An entity cannot simultaneously be the enterprise and the person who conducts its affairs. Permitting that would be tantamount to permitting an entity to associate with itself. Then she cites the Bennett case, the Hearst case, and the McCullough case. If, as the government claims, the objective of the enterprise was to promote the defendant and meet his personal needs, including his sexual activities, legal or not, the enterprise had no function unrelated to the defendant. They are one and the same. That the government did not and seemingly could not indict a single other member of this enterprise under a RICO theory reflects the absence of an enterprise distinct from defendant. Since this RICO prosecution is the first of its kind and likely the last of its kind, this court must look to civil RICO cases for guidance. Then she got in Riverwoods, the plaintiff claimed that through acts of extortion and mail fraud, the defendant Marine Midland Bank coerced Riverwoods to restructure loan agreements between Riverwoods and Westchester Federal Savings, later acquired by Marine Midland. Riverwoods purchased a property in Newcastle, New York, to develop residential condominiums and obtain a loan from Westchester Federal Savings for that purpose. Marine Midland, the hell now. Okay. Marine Midland later required Westchester Federal Savings and inherited the loan agreement. According to Riverwoods, shortly after the acquisition, Marine Midland officers communicated an intent to dishonor the loan. I'm sorry, guys, if I have to keep pausing to check my emails and stuff, because it may be something I have to do at work. So please accept my apologies in advance, okay? Agreement and engaged in extortive behavior to force Riverwoods to enter into a new loan agreement with terms more favorable to Marine Midland. In its complaint, Riverwoods alleged inter alia that through a pattern of racketeering activity, Marine Midland and two of its loan officers participated in the affairs of an association, in fact enterprise, known as the Restructuring Group, in violation of 18 U.S.C. Section 1962 sub C. The Second Circuit reiterated that under the plain language of the statute, the RICO person must conduct the affairs of the RICO enterprise through a pattern of racketeering, and that the person and the enterprise referred to must be distinct. The court emphasized that a corporate entity may not be both the RICO person and the RICO enterprise, acknowledging that the distinctness requirement could be satisfied where there is partial overlap between the RICO person and the RICO enterprise, and that a defendant may be a RICO person and one of a number of members of the RICO enterprise. Then she cites the Cullen case, the Cullen versus Margiotta. However, by alleging a RICO enterprise that consists merely of a corporate defendant associated with its own employees or agents carrying on the regular affairs of the defendant, the distinctness requirement may be circumvented. The Riverwoods court observed that because a corporation can only function through its employees and agents, any act of the corporation can be viewed as an act of such an enterprise, and the enterprise is in reality no more than the defendant itself. And she cites another case here in Birmingham versus Mogul, where employees of a corporation associate together to commit a pattern of predicate acts in the course of their employment and on behalf of the corporation. The employees in association with the corporation do not form an enterprise distinct from the corporation. The Second Circuit reached a similar conclusion, and she cites a case, Discon versus Ninex. Their Discon Inc. was a New York corporation whose primary business was to provide removal services to telephone companies. Discon argued that the defendant Ninex, a holding company that controls subsidies, MECO, and Nitel collectively, the Nitex defendants, conspired with AT&T Technologies to eliminate Discon from the market removal services by defrauding the public. Discon sued the Ninex defendants for civil RICO, alleging that the Ninex group, which consisted of Ninex, MECO, and Nitel, were three separate corporate persons that conducted the affairs of Nitex Group Enterprise through a number of illegal predicate acts. The Second Circuit observed that the distinctness requirement could not be circumvented by alleging a RICO enterprise that consists merely of a corporate defendant associated with its own employees or agents carrying on the regular affairs of the defendant. And she got here relying on the Riverwoods. The Second Circuit stated that where employees of a corporation associate together to a common. That girl keeps sending me that shit. Damn. Okay. Employees of a corporation associate together to commit a pattern of predicate acts in the course of their employment and on behalf of the corporation. The employees and associated with the corporation do not form an enterprise distinct from the corporation. The court observed that, like the defendants in Riverwood, Ninex, MECO, and Nitel, operated within a unified corporate structure, and even though they were legally separate entities, the relationship between NYNEX, MECO, I'm just going to call it MECO, and NITEL was not substantially different from that between the loan officers in Riverwoods in comparison to the bank. In both cases, the individuals defendants were acting within the scope of single corporate structure, guided by a single corporate consciousness. See also, and then she cites the case Atkinson's versus Anadarko Bank versus, and Trust Company. All right. Finding no enterprise distinct from the person where the defendant bank is holding company and three employees were not associated in any manner apart from the activities of the bank. Applying the rules of the foregoing cases, the government failed to prove an enterprise distinct from the defendant. By alleging a RICO enterprise that consists of defendant and his own employee's agent carrying on his affairs, namely promoting his brand, his music, and even assuming arguendo his sexual needs, the government fails to satisfy the distinctness requirement. Put differently, because the government alleged that defendants' employees associated together for purpose other than to carry out defendant's needs, including his illegal sexual activity. Wait a minute, guys. I keep hearing defendant, right? In the appellate, when you're in the appellate stage, you don't use that term. Am I right? It should be saying wherever he is, appellate defendant. I just caught that. I don't think he should be named as a defendant in this. He's supposed to be, it's the word, I haven't seen appellant in here at all besides the caption. But okay, I'm sorry, it just drew my attention. Purpose other than to carry out defendant's needs, including his illegal sexual activity, the employees did not form an enterprise distinct from defendant. Defendant and the alleged enterprise were one and the same. In sum, the government's theory of a RICO enterprise was flawed from the start. Okay? The government's evidence, taken in its best light, showed only that defendant employed a collective of people over his 25-plus year career who promoted his career and his music. They did not share an objective to commit sex crimes against women and girls. I can't even believe Judge Donnelly even thought some shit like that. That's why they forgave him the 30 years, because she gave him a year for each year he was in the business, because she thought this old sick shit. Dumbass. Accordingly, the government failed to prove him enterprise, and defendant's racketeering conviction must be vacated. Yes, must be vacated. Number 2, the government's evidence was insufficient to prove defendant guilty of violating the Mann Act as to Jane. Defendant was convicted of violating the Mann Act in connection with his sexual contact with Jane during 2 separate trips to California in 2015. In its superseding indictment, the government charged the defendant violated the Mann Act pursuant to 18 U.S.C. section 2421 sub A, when he arranged travel for Jane to California first in around April, May of 2015, and again in September, October 2015, with the intent of exposing her, some crazy shit, with the intent of exposing her to herpes, racketeering acts 8A, 9A, and count 2. Alternatively, the government charged that defendant violated the Mann Act pursuant to 18 U.S.C. section 2422 when he induced Jane to travel to California for the purpose of exposing her to herpes. Racketeering Acts 8B. The government also charged the defendant violated the Mann Act when he enticed Jane, a minor, to travel to California in September and October of 2015 for the purpose of violating California penal law sections 26 to, California penal law sections 261.5A and 26.5B, racketeering acts 9A and 9D, and counts 3 and 4. A, insufficient evidence of intent. Because defendant's motivating purpose in arranging travel for Jane to accompany him on tour in California on both occasions had absolutely, I know she meant to put in here, nothing. God damn. Okay, I know that's what she meant to put in there. Because defendant's motivating purpose in arranging travel for Jane to accompany him on tour in California on both occasions had absolutely nothing to do with exposing her. I know that's what it's just the word isn't there, but I know that's what she meant. To do with exposing her to herpes. The government failed to prove Section 2421A violations of the Mann Act. Similarly, defendant had no intent to induce or coerce Jane to travel to California to expose her to herpes as required by Section 2422A. Thus, racketeering acts 8A, B, and 9A and count 2 must be vacated. No, that's right. Section 2421A provides that whoever knowingly transports any individual in interstate or foreign commerce or in any territory or possession of the United States with intent that such individual engages in prostitution or any sexual activity for which any person can be charged with a criminal offense or attempts to do so shall be fined under this title or imprisoned not more than 10 years or both. The government superseding indictment, Racketeering Acts 8A and 9A and count 2, charged the sexual activity for which defendant could be charged was a violation of California Health and Safety Code Section 120290, which prohibits a defendant from willfully exposing someone to contagious, infectious, or communicable disease. Similarly, in this circuit, like others, to establish intent for Section 2421A purposes, the government must prove that a significant or motivating purpose behind the travel was to engage the individual in the charged illegal sexual activity. Then she cites a case, United States versus Miller, United States versus Soon Kim and Haywood. But see, Mortensen, she got all these case sites, holding that an intent must be the dominant motive of such interact movement. The illegal sexual activity must have not been merely incidental to the trip. Under the significant or motivating purpose standard, the government's evidence of intent was insufficient because the record fails to show that defendant intended to transport Jane to California at any time for the purpose of exposing her to herpes. Okay, that shit just sounds ignorant. That's just pure ignorance. The prohibited sexual activity charge. The government and the district court agreed that the purpose of the travel was not to expose Jane to herpes, but argued that the motivating purpose in bringing Jane to California was to have sex, and that because those sexual activities could have resulted in defendant being charged for violating the California Health Code for failing to disclose his herpes diagnosis, that government's proofs were adequate. The logic is gravely flawed as it reads the intent element entirely out of the statute. A, Section 2421A, violation of the Mann Act punishes travel plus intent to commit a prohibited sexual activity. In this case, that prohibited sexual activity is a violation of the California public health laws. The act is not so broad as to punish travel plus a violation of a state law that results after the fact. Indeed, the United States Supreme Court held long ago in that Mortensen case that she cited that the intent must be found to exist before the conclusion of the interstate journey. And she also cites another case, United States versus Haslag. The crime begins in the state where the defendant set out with the intent to cross the state line and commit the crime. And she cites United States versus Griffith, quoting in another community. It's another case she cites. The purpose of the Mann Act was to punish the government in interstate commerce of women and girls with a view of the accomplishment of the unlawful purposes prohibited. The district court is simply wrong when it suggests that to satisfy the intent element, a general intent to engage in legal sex that ultimately could be charged for reasons entirely unrelated to the original intent of the travel satisfies the element of a section 2421A violation. Consider the hypothetical where a man arranges to have his adult paramour travel to another state for sexual purposes, but once there, she declines his sexual advances and he sexually assaults her. Under the district court's logic, this would constitute a Mann Act violation, which it decidedly is not. It surely would constitute a crime under California law, but not a Mann Act violation. The Mann Act was never intended to be a tool to punish violations of state law, particularly violations of public health laws. The United States Supreme Court has warned courts to refrain from attributing to Congress an exercise of power to displace states in their traditional role of enforcing state criminal laws. Then she cites the United States case versus Lopez. With that established, the government simply did not prove that when defendant arranged for Jane to travel to California in either April 2015 or September 2015, he did so with a motivating purpose to expose her to herpes in violation of the California Health Code. Similarly, defendant did not, as a matter of law, violate Section 2422A, where even if he induced Jane to travel to California in April 2015, he didn't, as argued, infra. It was not with the intent or purpose to expose her to herpes. The government's proofs as to Racketeering Act 9D, count 4, suffer from the same illogic, although admittedly at first blush it appears to be a closer call. The government alleged that defendant transported Jane to California in September and October 2015 to engage in prohibited sexual activity, namely violation of California Penal Code Section 261.5A, 261.5B, unlawful sexual intercourse with a person under 18 years old, while defendant's sexual activities with Jane in California arguably could have been charged under California law. The fact remains that defendant's motivating purpose is bringing Jane to California on tour was not to violate the California Penal Code prohibiting sexual activity with individuals under the age of 18. Defendant and Jane had a consensual and legal sexual relationship in Illinois. Defendant's purpose in traveling to California was to perform. He arranged for his girlfriend to go with him. Jane herself admitted that the reason for the travel was for him to perform at his shows. that defendant had his girlfriend with whom he was engaged in a consensual sexual relationship in Chicago accompany him does not reflect intent to violate the prohibited sexual activity defined by California state law. If defendant had sexual relations with Jane in California in September and October, it was purely incidental to the purpose of the trip. Indeed, if defendant had not brought Jane with him, he likely and perhaps did bring one of his other live-in girlfriends on the trip as his companion. Sex was likely assumed irrespective of who defendant brought on his travels, which underscores that it was merely incidental to his travels rather a motivating and significant purpose of it. At bottom, no nexus exists between the transportation of Jane and the alleged illegal sexual activity charged as to any of the charged Mann Act violations. Hey guys, I'm going to pause for 1 second to catch my damn breath. What's up? What's up? What is happening in this chat? What is going on in here? And why I'm taking this break, I see more pages printed, and I think I need to reload some toner. So I'm going to take this minute and do that, guys. So chat amongst yourselves while I do that. Oh, good. It's not that many more pages that's printed. Oh, wait a minute. It probably is. I have to change the toner. Oh, give me a second. Uh-oh. I gotta change the toner. So I have to change the toner. I'm coming. Change the toner. Do I need to change both? No, I'm just going to change the black for now. I don't think it was telling me I need to change the other one. So I'm just going to... What do you guys think about the brief so far? Did she hit some key points? Let me know. Let me know your thoughts in the chat. What do you think about the brief so far? I need to put some more paper in here too. Okay. Put some more paper in here. Coming. I have to change the toner and paper. Y'all got a sister working this morning, baby. Man, the way that shit sound, the government, man, those some sick ass people. In my opinion, some dirty ass people. The shit they did. I told y'all they manufactured that shit. I wasn't making that up because I like R. Kelly. That shit, I'm calling it for what it is. Ain't got shit to do with how much I like to do. The shit was wrong. Period. All right. Greg, would you go get us some breakfast? I'm hungry. I hopped right on here. I didn't even eat. Trying to take care of you guys. I hope you appreciate it. Oh my God. Okay. Oh, this might be, is this all the pages? Oh, this might be all of it. Okay. But it was just telling me I need to change some ink. Okay. Insufficient evidence. Oh, wait a minute. Let me drink some more. Wait a minute. I want to see what you guys saying before. Did you guys answer my question about what do you think about the brief so far? Did anyone? Yes, Bonjean is on. Yes, right on. All of this for years. This man's life that he gets back. Bonjean is one hell. Yes, yes. Okay, cool. I was wondering. Good. Babe, would you go get us some breakfast? I'm sorry, guys, for yelling. Ugh, I'm hungry. Okay. Insufficient evidence of coercion or enticement. All right. Here we go. Separately, the government failed to prove a Mann Act violation pursuant to 18 U.S.C. Section 2422, where insufficient evidence exists to show that defendant knowingly persuaded, induced, enticed, or coerced Jane to travel to California in April 2015 or 2015. Wait a minute, you guys. Okay. Okay. 1, April, May 2015, trip to California. The government's evidence showed that defendant invited Jane to come see him perform in California after they commenced an intimate relationship in Florida. There was no inducement or enticement on the part of the defendant. Indeed, Jane's testimony and contemporaneous text messages between Jane and her mother reflect, and she put the, making reference to is what it, ooh, I can't wait for that panel to go to those sections of the damn appendix. Okay, that at the direction of her mother, Jane deceived defendant about her age and carried out a plan. I told you guys, Jennifer, that she was working strategically in that damn court. She had to put that shit in here. Yay! That's what I wanted to see. That at the direction of her mother, Jane deceived defendant about her age and carried out a plan to meet him and engage him in a relationship, not the other way around. You know that's right, Jennifer. To be clear, defendant concedes that neither Jane nor her mother's conduct, no matter how troubling, would be a defense to this charge if defendant did, in fact, induce or entice Jane to travel to California for illegal sexual activity. But the evidence shows only that defendant invited Jane to travel to California to attend a concert, reasonably believing her to be 18 years of age, and she accepted. Okay. After attending one of defendant's performances with her parents in Orlando on April 11, 2015, Jane's mother obtained defendant's phone number and began communicating with defendant, posing as her. Then she put that shit in there. They trying to say that shit was fake. Jane eventually communicated directly with the defendant via FaceTime and told him she was 18 years of age. Jane did not reveal her true age until months later. On April 20th, 2015, Jane's mother, still pretending to be Jane, arranged for Jane to meet defendant ostensibly to audition for the defendant. However, Jane and her mother were aware that defendant, believing Jane to be 18, was also interested in Jane sexually. He was interested in her ass sexually because that damn mama, them damn conversations they were having during that text shit. That's where that come from. In one text, Jane's mother texted her daughter stating, "This man is trying to screw, but I'm trying to make it business. He knows you're a singer, but he ain't playing. He want to fuck tonight." Ooh. Despite that Jane and her mother, but did she put that shit in it? You go, Jennifer. She put that shit in there, and she put it in there. Despite that Jane, that panel is going to trip when they read this shit. Despite that Jane and her mother were on notice that defendant was interested in Jane sexually, Jane's mother encouraged Jane to entice the defendant. Be prepared to sing 3 songs. He said he will meet you and listen to your song. Please have your glasses off, hair to side. Mama knows best, pretty hurts. And third, your choice don't no. Wait a minute, let me read that over. Be prepared to sing 3 songs. He said he will meet you and listen to your song. Please have your glasses off, hair to side. Mama knows best, pretty hurts. And third, your choice don't yell. Put on a show, dance, grab his hand, shimmy, wiggle, sit on his lap, entice him. While singing is all about performance. This your chance and opportunity. Don't blow it. Jane's mother even told Jane not to look grown. Emphasis added. Didn't she tell us? But didn't she? Oh my God. After their first encounter, Jane and defendant continued to text at the encouragement of Jane's mother, and defendant eventually invited Jane if she wanted to attend his concert in California. Jane reported back to her mother, Jane, and I talked to R. Kelly, Mom. Yeah, about what? Jane, laugh my ass off about flying me out, Mom. Oh, really? When? Jane, yeah, whenever I tell him he can. Tomorrow if I choose, Mom. Oh, yeah? Sick ass mama. On April 28, 2015, Jane traveled. Jennifer put all that shit in there. She put it all in there. Go on, girl. On April 28, 2015, Jane traveled to Los Angeles, California to meet defendant with the knowledge and consent of her parents. At no point did Jane express any apprehensions about being with the defendant or ask her mother to arrange for her to come home. When Jane excitedly told her mother that she was riding defendant's tour bus to Stockton to attend his concert, Jane's mother responded, "Oh my God, exciting, you riding on the tour bus?" Yeah, all right. On May 1st, 2015, Jane's mother urged Jane to take advantage of defendant texting her, quote, "It won't be star lifestyle if you don't get serious about your music and show this man you want to be famous like him. Once he tired of you, you'll be like anybody else. You better use this as your opportunity while you got him in spell." Oh, hell, I bet you that's exactly how her ass sound too. Jane's mother then said, quote, "You should text him and be like, you know you gonna be my boo, and see what he say." To Jane responded, "Laugh my ass off." Jane traveled with defendant from Los Angeles. Gone, Jennifer. Girl, I'm so glad you put this shit in there. And you know she attached the damn messages. Jane traveled with defendant from Los Angeles to Stockton, California, telling her mother, he asked me, did I want to come to his show? I said, of course. And he said, okay, then I'll pack this stuff up. He was even putting his stuff in my bag. Jane and her mother maintained in constant communication before defendant's show. Jane's mother instructed her about what to wear and made suggestions about how she should behave at defendant's show. Quote, "I would blow him a little kisses and wink at him and bite the tip of my finger and mess with him real good. Do something seductive, then make a silly face, laugh out loud." Jane and her mother continue to text throughout defendant's performance. At one point, Jane's mother suggested that Jane would marry the defendant and that her son-in-law would be older than her, Jane's mother. According to Jane, she and defendant had sexual intercourse for the first time after the concert. No rational juror could conclude that defendant enticed, persuaded, induced, or coerced Jane to travel to California. Go, Jennifer! Jane's testimony, along with contemporaneous conversations with her mother, show that defendant invited Jane to join him and she accepted. The government suggested that defendant's mere act of arranging for Jane's travel is sufficient to demonstrate that he induced her to travel to California because he caused her to travel. Now, you know that's some BS, right? Because y'all all know the government already had those damn text messages. And you see how they still proceeded on with that shit? They knew. That's some scandalous ass people. The law says otherwise. The Second Circuit has made clear that the terms persuade, induce, entice, and coerce are words of common usage to have plain, ordinary meanings. Then she cites the case United States versus Wakwa or some shit. I don't know. The court distinguishes this conduct from merely asking, which is not sufficient to demonstrate criminality, recognizing that there might be some uncertainty as to the precise demarcation between persuading, which is criminalized, and asking, which is not. Where the government concedes the defendant was operating under a reasonable belief that Jane was 18. Jane and her mother knew that the defendant was interested in Jane sexually from the jump street, and defendant merely invited Jane to meet him in California to attend his concerts. The government failed to prove coercion or enticement. An invitation, even from a famous recording artist, is not presumptively enticing or coercing. The government's evidence failed to show that Jane was persuaded, induced, enticed, or coerced into traveling to California. She was invited and she accepted the encouragement. She accepted at the encouragement of her mother, knowing full well that defendant had sexual interest in Jane, who had believed to be legally consenting age. 2. September, October 2015, trip to California. The government charged defendant with Mann Act violations pursuant to Section 2422 A and B under the separate theory that defendant did knowingly and intentionally persuade, induce, entice, and coerce Jane to engage in prohibited sexual activity under California Penal Law Sections 261.5A and 26.5B. Unlawful sexual intercourse with a person under 18 in September 2015 and October 2015 is already discussed. Supra, the government failed to prove an intent to travel for the purpose of violating California statutory rape laws, where he was engaged in a legal sexual relationship with Jane in the state of Illinois. Furthermore, the government simply failed to prove that defendant took any action to induce, persuade, entice, or coerce Jane into traveling to California. Jane did not testify that defendant took any actions to persuade, induce, entice, or coerce her to engage in prohibited sexual activity while the two were in California as a result of his in September, October 2015. Defendant and Jane were in sexual relationship based primarily in Illinois, where defendant and Jane resided at that point. Although Jane testified that defendant had already started engaging in a controlling fashion, she didn't testify that he coerced or enticed her to accompany him on tour. Jane traveled with defendant to numerous states as one of his partners. She went consensually and voluntarily and remained defendant's partner until 2019. Defendant did not have to induce, persuade, entice, or coerce Jane to travel to California for prohibited sexual activity, even if Jane later characterized the relationship as abusive. The government's, they should, she, oh, damn, whatever. The government's main act theories were defective from the start, where the government distorted the purpose of the act and stretched its commerce power beyond all limits, making it difficult to imagine a scenario where the federal government could not exert its control into traditional areas of state control. The government's proofs, as a matter of law, were insufficient, and the court must vacate defendants' convictions for racketeering acts 8 and 9, counts 2 through 5. 3. The government's evidence was insufficient to prove defendant guilty of violating the Mann Act as to faith. The government charged defendant with multiple violations of the Mann Act in connection with 2 sexual encounters with Faith in New York. Specifically, the government charged defendant with violating 18 U.S.C. Section 2421A and Section 2422A in connection with a sexual encounter that occurred in New York on May 18, 2017, Racketeering Acts 12A, 12B, and count 6 and 7. And another encounter that occurred on February 2nd, 2018. Racketeering Acts 14A, 14B, and counts 8 and 9. A. Insufficient evidence of intent. Racketeering Acts 12A and 14A, counts 6 and 8, charged that defendant transported Faith to New York on 2 separate occasions, May 18, 2017, and February 2nd, 2018, with the intent to engage her in sexual activity that would expose her to herpes in violation of New York Penal Law, Section 120.20, reckless endangerment, and Public Health Law, Section 2307. Section 2307, okay. Knowing exposure of infections, venereal disease. Because there is no link connecting defendant's transportation of Faith with intent to expose her to herpes, defendant cannot, as a matter of law, be guilty of the charge, Section 2421A violations. As discussed at length, supra, the government must prove that the charged illegal sexual activity is a significant or motivating purpose behind the transportation. Then she cites the Miller case. Because the defendant purported violation of a New York public health law prohibiting him from exposing a partner to herpes and reckless endangerment was incidental to Faith's trip rather than a motivating purpose in transporting Faith to New York. The intent requirement of the statute cannot be sustained. As previously discussed, defendant must possess an intent to carry out the prohibited sexual conduct prior to the travel. The government misled the jury concerning the law, which would explain why the jury returned guilty verdicts on these counts. When it argued that defendant transported Faith to New York for the purpose of sex, the only remaining issue is whether the sexual activity that he brought her here for was illegal, and it was. R433. This argument falsely suggested that the government only needed to show a general intent to transport Faith to New York for sex. irrespective of whether he possessed an intent to engage in illegal sexual activity. As addressed supra, the government proves a section 2421A by showing transportation plus intent to commit unlawful sexual activity, not intent to commit lawful sexual behavior that may result in illegal conduct. Thus, the government was required to show that the motivating purpose behind defendant's transportation of Faith was to expose her to venereal disease in violation of the specific offense charge. The same is true in connection with the Section 2422A offense, where even if the government showed that defendant persuaded, induced, enticed, or coerced Faith to travel to New York, his motivating purpose in doing so was not an intent to expose her to herpes. B. Insufficient evidence of coercion or enticement. Racketeering Acts 12B counts 7 and 14B counts 9. Similarly charged that defendant did knowingly and intentionally persuade, induce, entice, and coerce Faith to travel to interstate commerce to engage in sexual activity that would expose her herpes in violation of NYPL section 120.20 in New York Public Health Law section 2307. The government failed to prove that defendant took any action to induce, persuade, entice, or coerce Faith into traveling to New York on May 18, 2017, and again on February 2nd, 2018. Defendant's mere status as a famous recording artist cannot satisfy the government's burden to prove enticement or coercion. Rather, the undisputed evidence shows only that defendant invited an adult woman to meet him in New York, and she accepted. Okay. In March 2017, Faith attended one of defendant's concerts in San Diego, Texas, with her sister. Faith had an opportunity to meet defendant at an after party backstage along with other individuals. Defendant and Faith had a conversation during the after party, and defendant provided her with his phone number. After the encounter, Faith and defendant kept in touch via text and FaceTime. The conversations were normal, appropriate, and pleasant. Defendant complimented her appearance. Faith testified that defendant referred to himself as daddy during those conversations. According to Faith, so damn what? According to Faith, defendant asked to be called by daddy, and she agreed, dumbass. But you gonna blame him. Girl, shut up. Faith did not testify that defendant forced her to call him daddy. Let me see. Faith did not testify that defendant forced her to call him daddy. Indeed, defendant and Faith had met exactly one time when Faith began calling him daddy. Lord, oh Lord, little money hungry ass helper. That's all that shit was. On the issue of travel, Faith had this to say. Question. In your communications with defendant, how, if at all, did the topic of traveling to see him come up? Answer. He had informed me that he was on tour right now, or excuse me, at the time. He was on tour, so he was just saying his schedule was kind of crazy, but whenever I wanted to come see him, I could, and just said that he could arrange the days or just let him know when I wanted to come hang out, but that it would be fun. I would get to see, you know, how it is, how he is on tour, things like that. Defendant told Faith that if she wanted to come to his shows, she could contact his assistant and he would arrange it for her. Faith then contacted defendant's assistant, who made travel arrangements for her. Originally, Faith was going to travel to Chicago, but ultimately traveled to New York for one of defendant's performances. According to Faith, defendant informed her that he was having a show in New York and that he would like for me to come hang out. Is this still in quotes? That kind of threw me. Okay. Ultimately traveled to New York for one of defendant's performances. According to Faith, defendant informed her that quote, that he was having a show in New York and that he would like for me to come hang out. It was going to be fun. So I did, end quote. Defendant's assistant arranged her travel, and Faith traveled to New York to attend defendant's performance and hang out. The Second Circuit has made clear that terms persuade, induce, entice, and coerce are words of common usage that have plain, ordinary meanings. And she states the case, United States versus Wakwab and Garlardy or something like that. The court distinguishes this conduct from merely asking, which is not sufficient to demonstrate criminality, recognizing that there might be some uncertainty as to the precise demarcation between persuading, which is criminalized, and asking, which is not. No rational juror could conclude from Faith's testimony that the defendant coerced or enticed her to travel to New York for the purposes given her herpes, no less. By Faith's account, the defendant was polite, generous, and appropriate, leaving it entirely at her discretion to come to New York to attend the concert. Defendant's invitation does not equate to inducement or persuasion. Go on, Jennifer. C, New York Penal Law 120.20, reckless endangerment. Oh, shit, I haven't been checking my things. Okay. Ain't shit happening. I don't think. Wait a minute, guys. I'm sorry. I forgot all about I'm working shit. I got to check my emails. This effort still does not answer my damn question. Okay, I'm sorry, guys. Damn, where I leave out at? Oh, shit. I'll read it over. I'm sorry. I'm going to just read this over. I don't know. I'm checking that damn email through me off. Oh, shit. All right. To the extent defendant's Mann Act convictions rest on violations of NYPL 120. Oh, yeah, okay, that's right. To the extent defendant's Mann Act convictions rest on violations of NYPL 120.20. The government failed to sustain its burden because unprotected sex with a person who carries the herpes virus does not establish a, quote, substantial risk of physical injury, end quote. No New York court has ever found as such. Indeed, as best as defendant can tell, no one has ever been prosecuted in the state of New York for reckless endangerment for exposing a sexual partner to herpes who was not infected with herpes. Needless to say, the law on this issue is lacking. At the outset, Faith did not contract genital herpes. Faith claimed that at some point in time after she visited New York, she was diagnosed with herpes type 1 after getting a cold sore on her mouth. She did not testify that she contracted genital herpes, and there is no evidence that she did. Well, her mama sure in the hell said she didn't. Presumably, even the government would concede that cold sores caused by herpes type 1 and carried by 50% of the population, and there's a footnote where she put in links where this can be verified, Does not cause a substantial, does not cause a substantial risk of serious physical injury. I'm sorry, guys. Like I said, I'm working and trying to get this to you guys at the same time, but I got to make sure I'm responding to shit in a timely fashion. Furthermore, as a matter of law, unprotected sex with someone who has genital herpes does not establish a substantial risk of serious physical injury. According to the city health department, 1 in 4 New Yorkers has genital herpes. She also put a link to that. That's a footnote. That's footnote number 6, actually. If sexual intercourse with individuals who merely carry the genital herpes the genital herpes virus carries the substantial risk of serious physical injury. New York City would have astronomical hospitalization and death rates from the transmit. Damn, New York is infected with that shit. And death rates from the transmission of herpes. Although Dr. Hoskins, the government's expert witness, identified some serious but unusual health risks associated with the contraction of genital herpes, the offense of reckless endangerment requires a showing of a substantial risk of serious physical injury. End quotes, end quotes. To be clear, defendant accepts that in rare circumstances, someone afflicted with herpes could suffer serious physical injury. But here, the government did not prove that Faith faced substantial risk of being infected with herpes or that a substantial risk that would suffer the rare complications that would satisfy the serious physical injury element. Dr. Hoskins estimated that there exists a 10% to 20% chance of a risk of transmission when someone is managing their infections with bowel tracts, as defendant was. This hardly qualifies as a high risk of transmitting the disease, nor does it consider the even lower risk that someone who contracts the disease will suffer the rare complications that would qualify as serious physical injury. Herpes is not deadly. It's treatable, if not curable. I don't think it's curable. I don't think they found a cure yet, but whatever. And rarely causes any serious protracted health impairment. That's footnote number 7, where she also put a link. Complications associated with herpes carry a low rather than substantial risk of serious physical injury as defined by the statute. The government cannot, as a matter of law, sustain this claim. In short, merely having unprotected sex with someone who carries the virus cannot, as a matter of law, create a substantial risk of 1, being infected with the disease, and 2, suffering the rare complications that qualify as a serious physical injury. The government cannot point to a single case that supports the prosecution's expansive reading of this statute. D, New York Public Health Law, Section 2307. To the extent defendants' Mann Act convictions rest on violations of New York, I guess that's that public health law, Section 2307, the government failed to sustain its burden. Because there was no evidence presented at trial demonstrating the defendant was infected. Thank you, Jennifer. I'm reading that shit again. The government failed to sustain its burden because there was no evidence presented at trial demonstrating that defendant was, in quotes, infected with the venereal disease during his sexual interactions with Faith, which explains why she never contracted genital herpes from the defendant. Go, Jennifer. New York Public Health Law, Section 2307 reads, Section 2307, venereal disease, person knowing himself to be infected, any person who knowing himself or herself to be infected with an infectious venereal disease has sexual intercourse with another shall be guilty of a misdemeanor. Okay? By the plain terms of this antiquated provision, a defendant must know himself to be infected with an infectious venereal disease to violate the provision. The government and the district court interpreted infected to mean merely carrying an infectious disease rather than having a herpes related infection. The statute is silent as to the definition of infected. Jennifer, you gone, girl. The word infected in the statute must be oh shit, I gotta hurry up because I got a meeting. Damn. The word infected in the statute must be interpreted to mean active infection to avoid constitutional concerns. It is axiomatic that most courts, state and federal, would generally interpret statutes as to avoid constitutional difficulties. Expression, and then she cites the case Expressions Hair Design versus Scheidemann. As the evidence at trial showed, herpes is a virus that may constitute a venereal disease, but it does not follow that having the virus equates to having an infection. That said, an active outbreak of herpes where someone experiencing blistering and open sores that would give them notice that they are contagious would qualify as an infection. The only logical and constitutional reading of the statute requires the government to show that defendant was experiencing a herpes infection at the time of his sexual encounter with Faith, which would have put the defendant on notice of the possibility of transmitting the disease to a sexual partner. If this is not the case, then New Yorkers are violating this public health law every minute of every day without consequence. The government presented no evidence that defendant was experiencing a herpes-related infection during his sexual. You mean to tell me they couldn't see that shit if he was? I know damn well they wasn't checking his shit out. These girls full of shit. The government presented no evidence that defendant was experiencing a herpes-related infection during his sexual encounters with Faith, and Faith admitted that she did not contract genital herpes from the defendant. Accordingly, the government failed to prove a violation of New York Public Health Law, Section 2307. 4. Because New York Public Health Law, Section 2307 is unconstitutionally vague, defendants' Mann Act convictions predicated on the law must be vacated. The government's Mann Act, thanks, Big Vi. The government's Mann Act convictions as to Faith are predicated, in part on his alleged violations of New York Public Health Law, Section 2307, discussed above. Prior to his trial, defendant unsuccessfully challenged the constitutionality of the law on due process grounds. The Fifth Amendment provides that no person shall be deprived of life, liberty, or property without due process of law, end quote. Then she states the Johnson versus United States case. In Johnson, the Supreme Court observed that, quote, our cases establish that the government violates the guarantee by taking away someone's life, liberty, or property under a criminal law so vague that it fails to give ordinary people fair notice of the conduct it punishes, or so standardless that it invites arbitrary enforcement, end quote. The prohibition of vagueness in criminal statute is well recognized requirement, consonant alike with ordinary notions of fair play and the settled rules of law. And a statute that flouts it violates first essential of due process. These Fifth Amendment principles apply to state laws through the Fourth Amendment. The Due Process Clause of the Fourth Amendment requires that every criminal statute, one, give the person of ordinary intelligence reasonable opportunity to know what is prohibited and to provide explicit standards for those who apply the statute. Then she cites the Dickerson versus Neapolitano. A plaintiff making an as applied challenge must show that the statute in question provided insufficient notice that his or her behavior at issue was prohibited. Even if a person of ordinary intelligence has notice of what a statute prohibits, the statute nonetheless may be unconstitutionally vague. If, quote, if it authorizes or even encourages arbitrary and discriminatory enforcement, end quote. It at 747. New York Public Health Law Section 2307 fails both prongs of Dickerson tests by failing to define, quote, infection or including a mental state other than, quote, knowledge. The statute fails to put people of ordinary intelligence on notice of what conduct is prohibited. Furthermore, this court need look no further than this case to see that the statute authorizes or encourages arbitrary or enforcement. As best as defendant can tell, he is the only person in New York history who has been prosecuted for violating this statute where the victim was not infected with the venereal disease. Ain't that some shit? 1 in 6 Americans, 1 in 4 New Yorkers suffer from genital herpes complex 2. And she got she put a footnote with the link so they can check that out. As discussed previously, although herpes in not, I know that's supposed to be is, okay, although herpes is not curable, there are highly effective treatments for herpes that prevent infection under the plan. Under the plan reading of this statute. Even a person who carries the virus but who has been asymptomatic for decades would commit a crime by having sexual intercourse with another, irrespective of whether he disclosed his status to his or her partner. In the absence of a definition of infected, quote, infected, the statute is unconstitutionally vague. The government and the district court's interpretation of the statute is highly stigmatizing to the millions of individuals who have been diagnosed with herpes simplex 2. The disease is easily treated with a suppressive drug regimen, and people often experience complete remission from infection. While the district court assumed that, quote, infected meant having the virus rather than having the ability to transmit it, no authority supports the application, and such an interpretation not only fails to appreciate how many people carry this virus, but would also lead to arbitrary and discriminatory enforcement. Indeed, under the government's interpretation of the statute, it seems likely that every sexual active person in the state of New York is routinely violating the statute. Human papillomavirus virus is a sexually transmitted disease that according to the Centers for Disease and Prevention is so common that nearly all sexually active men and women get the virus at some point in their lives. Then she put another, that's a footnote 9, with also a link to check that out to verify that. A person of ordinary intelligence would have no idea that they are prohibited from having sex in the state of New York if they have HPV, which would probably constitute 90% of the sexually active population. In sum, New York Public Health Law, Section 2307, is unconstitutionally vague, and this court must vacate defendants' Mann Act convictions to the extent that they rely on this unconstitutionally vague statute. 5. Defendants' Mann Act convictions predicated on a violation of California Health and Safety Code, Section 120290, must be vacated because the government charged defendant with a repealed version of the statute that was unconstitutionally vague. Dirty ass. The government charged defendant with several Mann Act violations predicated on defendant's alleged violation of California Health Safety Code, Section 120290. However, the government charged defendant under a repealed version of the statute no longer in effect. No shit. What the hell? Prior to the jury charged in this case, defendant notified the court that the jury instructions did not reflect the elements of California Health and Safety Code, Section 120290. The government acknowledged as much, but argued that it charged defendant under the statute that was in effect in 2015, not the current statute. What the hell? How did these people? Thank you, Love Lives Here. Oh my God, what the hell? Them dirty, but oh my God. Y'all want to trust the damn government? Are you serious? Whew. The government had no authority to charge defendant with a statute that was repealed or inoperative at the time of prosecution. And she states the United States versus Chambers case. In case a statute is repealed or rendered inoperative, no further proceedings can be had to enforce it in pending prosecutions unless competent authority has kept the statute alive for that purpose. That damn government is something else. In 2015, Section 120290 of the California Health and Safety Code provided, except in provided in Section 120291, or in the case of removal of an inflicted person in a manner the least dangerous to the public health, any person afflicted with any contagious, infectious, or communicable disease who willfully exposes himself or herself to another person, and any person who willfully exposes another person inflicted with the disease to someone else is guilty of a misdemeanor. The statute was overhauled entirely in 2018 after the California legislature determined that it was antiquated, having been passed during an era of discrimination toward those affected with HIV. And she put a footnote there. That's footnote number 10. The bill analysis for the 2018 enactment sets forth the legislative history and rationale for repealing the rationale for repealing the version under which defendant was prosecuted. And there's a link there for that. Okay. The current statute bears little to no resemblance to the repealed 2015 version, least of all because it now requires a showing of a specific intent to transmit the disease. Although repealed, the government proposed a jury instruction, the dirty bastard, that reflected the elements of the statute in effect in 2015. Apparently, recognizing that the 2015 statute was unconstitutionally vague, the government included elements in its jury instruction that were not included in the state as written by the California legislature. No shit. Legislature. Thus, the government not only charged defendant with a repealed statute, but rewrote it in clear violation of various constitutional provisions, including the separations of power clause and principles of comity. I think it's comity. Defendant's jury was instructed pursuant to a statute that never existed. A California court has no authority to rewrite a California statute, and neither did a district court sitting in New York. No, that's right. Even if the government had the authority to charge defendant under the 2015 version of Section 120290 of the California Health and Safety Code, the statute did pass constitutional muster. I don't know if that's muster. Okay, but she has muster. Most obviously, the statute is void for vagueness, both on its face and as applied to the defendant, because it simply did not give a person of ordinary intelligence a reasonable opportunity to know that is prohibited, nor did it provide explicit standards to those who apply the statute. Then she cites the Dickerson. The statute also leads itself to arbitrary and discriminatory application. Again, defendant appears to be the first person in California's history to be charged under this statute, where the alleged victim was not actually infected with the disease during the conduct that occurred in California. As written, the 2015 law failed to provide adequate definitions about what diseases the statute meant to address when it criminalized willful exposure, and that's in quotes. Of all allegedly communicable diseases, including those not sexually transmitted, the statute is silent on what is meant by willful exposure, end quote, and makes no mention of whether the defendant could willfully expose someone to a disease without possessing the knowledge of his ability to transmit the disease, or without even knowing she has the disease. Indeed, it seems likely that the California legislature repealed this statute in part because of its unconstitutional vagueness. Just by way of example, the statute would criminalize passing along cold sores. Nearly 50% of the population has herpes type 1, a communicable disease. Under the 2015 statute, anyone with herpes type 1, also known as cold sores, who kisses another person would be guilty of a misdemeanor, even if the afflicted person had no active infection, outbreak, and did not pass the disease along to the recipient of the kiss. Under this statute, parents with herpes simplex 1, again, 50% of the population, would be prohibited from kissing their own children. One cannot imagine how many arbitrary prosecutions could take place in this current era of a pandemic if this law was in effect today. The examples of how this statute could be misused for arbitrary and discriminatory purposes. In its order, and then she put where to look, the government, oh shit, wait a minute. Okay, wait a minute. Give me 1 second, guys. I got to pause for 1 second. I'm sorry. That's why I should have waited. before I even started work. But I want to get this out. Give me 1 second. Hey, sorry guys, I'm back. Okay. The government faults defendants through his trial counsel for failing to challenge the indictment or the constitutionality of the statute earlier. This reason is simply this. Oh wow! I bet you that's supposed to be. This reason is simple. Yep, I bet you that's what that's supposed to be. This reason is simply. Oh, I don't know what she meant. I don't know what that means because I know that's not right. The reason is simply, and then there's a period. That doesn't make sense, but that's what's in here. The reason is simply. I'm going to leave it what she has. Trial counsel had no idea that the government intended to charge the defendant pursuant to a repealed and inoperative statute. Although indictment cites to the statute and notes, quote, effective 1998, end quote, this language did put defendant on notice that the government intended to charge him pursuant to the repealed version of the statute. Indeed, the first time trial counsel recognized the issue was prior to the finalization of jury instructions, which he objected to the government's proposed instruction that did not track the language of the current statute. Contrary to the district court's view, the government cite to the California statute with the words, quote, effective 1988, end quote, did not alert the defense of an intent to charge a repealed statute. Indeed, it was entirely reasonable to assume that the government would not be charging a repealed statute that was clearly unconstitutional, as the government legislator understands, but EDNY does not. Defendant has shown, quote, good cause, end quote, for failing to raise the issue earlier. In sum, the Racketeering Act premised on a violation of this repeal. An otherwise unconstitutional statute cannot stand. How we doing, guys? How we doing? How we doing? How we doing? You guys gonna kill me if I don't finish this because I got a telephone conference. I am so sorry that I have to do at 11. So I'm hoping I'm done by then, but I'm giving you a heads up. You know I hate to have to pause when I'm damn near almost done. But I just want to give you a heads up on that. That damn conference and these damn telephone conference, this shit. We don't even really need to do this shit every day, but we have to have those phone conferences if we're not in the office every damn day. So sorry, guys. Let's see. I'm gonna read this part over. Defendant has shown good cause for failing to raise the issue earlier. In sum, the Racketeering Act, premised on a violation of this repealed and otherwise unconstitutional statute, cannot stand. Number 6, the government failed to prove defendant guilty or of forced labor or of geranda and faith based on an isolated sex act that neither victim alleged was forced. Okay. They just go, ooh, these people, oh my God. All these assholes, man, your day coming. This is some bullshit. The government alleged that defendant committed the crimes of forced labor when he directed Geronda and Faith to perform an act of oral sex on him on January 23rd and wait a minute. Perform an act of oral sex on him on January 23rd, 2010 and January 13th, 2018. What? Ain't that some shit? They ain't have to do it. He do it, baby, bye. This is some shit. This is just ridiculous even reading some of this shit. Because are you serious? I can't believe, just seeing this shit in black and white, this shit is really pathetic to me. It really is. The pancakes and sausage. Thanks, baby. Where neither Geronda nor Faith characterized the isolated sex as forced or rational. As forced. No rational juror could conclude that defendant knowingly obtained or agreed to obtain any labor of services from them. These charges are yet another example of the government's transparent effort to stretch a statute far beyond its intended purpose, to which conduct that can no longer be reached by the statute authorities. A conviction of forced labor under 18 U.S.C. Section 1589 requires the government to prove beyond a reasonable doubt that 1, the defendant obtained the labor or services of another person, 2, through inter alia threats of serious harm, and 3, the defendant acted knowingly. Then she cites the case United States versus Marcus. The statute does not define labor or services, but is given its ordinary meaning. In quotes, labor means the expenditure of physical or mental effort, especially when fatiguing, difficult, or God damn it, I know this damn word and I'm not saying it. Let me see. Especially when fatiguing, difficult, or compulsive. Fuck! I hate that. I'm tie-tongue on this word today, and I see it damn near every day. Compulsory, while service is defined as the performance of work commanded or paid by another. And she cites the United States versus Marcus case again. Additionally, the government must establish a causal link between the labor and services provided by the person and the threat of serious harm. Section 1589 is intended to address serious trafficking or cases where traffickers threaten harm to third persons, restrain their victims without physical violence or injury, or threaten dire consequences by means other than overt violence. Then she cites a case, Muchara versus Araroff, some shit. The harm or threat of harm considered from the vantage point of a reasonable person in the place of the victim must be sufficiently serious to compel the person to remain in the condition of servitude when she otherwise would have left. According to the government, on January 2010, defendant violated the forced labor statute by using threats of violence to obtain labor, an act of oral sex. Now they saying this, he's a damn, thanks Elisol. They saying this megastar, right? Mind you, he was a damn megastar. They saying this megastar forced labor, forced these women. I can't even believe they believe that shit. By using threats of violence to obtain labor, an act of oral sex from Geronda. Accepting the government's evidence in this best light, Geronda described an isolated incident in which the defendant assaulted her because he was angry that she disrespected him. Geronda testified that after the assault, she sat down with defendant in the VIP room and he instructed her to perform oral sex on him. But you gonna blame him, her dumb ass, stupid ass. Geronda complied. Geronda did not testify that defendant threatened her, forced her, or even demanded that she give him oral sex. Geronda did not claim that she feared defendant would assault her again if she declined the request. Just reading this shit pisses me off. Geronda did not even testify that she did not want provide. I'm sure she wanted to say, God damn it. I'm sure the word is not there, but I'm sure this is what she's saying. Geronda did not even testify that she did not want to, I bet you that's what should go there, want to provide defendant oral sex. After the incident, Geronda left defendant's home on her own free will. Accepting Geronda's account is true, okay? It simply does not establish an act of forced labor. An isolated act of oral sex does not qualify as a labor of services, where there is no commercial aspect to the incident and the victims never testified that they expected any type of benefit from the act. Moreover, the record does not show that Geronda gave oral sex to the defendant out of fear of threats of violence, notwithstanding the prior assaultive behavior. It would not have taken much for Geronda to make the causal link between the act of oral sex and her fear of physical assault by the defendant, but she simply didn't. The jury was not free to jump to such a conclusion in the absence of Geronda's testimony, particularly where this event was an isolated one. Similarly, no rational juror could conclude based on the evidence adduced at trial that defendant knowingly obtained or agreed to obtain any labor of services from Faith on January 13, 2018, who testified that she traveled to Los Angeles to see defendant with whom she had been having a romantic relationship. She described an incident where she and defendant were in a small room in his studio. Faith claimed there was a gun. Okay, and was it pointed at your ass? See, reading this shit pisses me off. Was it pointed at your ass, though? Faith claimed there was a gun in the room that made her intimidated, but conceded the defendant never threatened her with it. So why even talk about it then? So damn what? You saw a gun or made any gesture that he intended to use it. Faith was simply uncomfortable by its presence. So why didn't you just ask the man, hey, Robert, this gun is scaring me. Can you put it away? What the hell was wrong with doing that? You people are fake as hell. Faith was simply uncomfortable by its presence. After an intense conversation during which Faith described defendant as being serious but not threatening, defendant directed her to give him oral sex and grabbed her neck before placing his penis. Well, that's the only way the shit can be performed, people. I know it sounds foreign to some of you asses, but that's how it's done. Defendant directed her to give him oral sex and grabbed her neck before placing his penis inside her mouth. Without objection, Faith provided oral sex to defendant, although she testified that she did not want to. Girl, get your ass out of here. Why did you do it then if you didn't want to? Girl, oh, Lord. Okay, whatever. Faith herself refuses to identify as someone who has forced to do anything. On cross-examination, Faith admitted that she was not a victim. So why is we even talking about her ass then? Why is she even in this shit? Faith admitted that she was not a victim and had made a choice to be with defendant. Question. In one of the podcasts we spoke about this morning, the paper route. On that show, you said during the interview, I don't like the word victim because I don't feel like I'm a victim. I'm a young woman. And let's be clear. Let's be clear. I made a choice to be involved with that person. Do I feel like everything he did was right? Hell no. But I had a choice. And that's why I walked away. I did not move in with him. I did not live with him. I did not take any money from him. There is a choice that you have to make. You said that. Answer, correct. Question, you made a choice? Answer, correct. Question, and you're not a victim? Answer, correct. The forced labor statute was not enacted to remedy isolated occurrences like the one described by Faith. Indeed, it's not even clear from Faith's testimony that she communicated to defendant that she did not want to give him oral sex. She certainly, that girl was giving head before she even hooked up with that damn man. They played y'all ass. She certainly did not end her relationship with defendant after this episode. The record fails to reflect a causal link between the isolated act of oral sex and any threat of physical violence. Absent clear expression of congressional intent, courts should resist the urge to transform the forced labor statute to cover circumstances alleged in Racketeering Act 6, which bear virtually no resemblance to those pragmatic forced labor cases and their victims. Then she cites a case here, Tolabov or something, Tababi, that's probably what it is, describing prostitution, forced sweatshop work, and forced domestic service as paradigmatic forced labor cases. Paradigmatic forced labor cases. Geronda and Faith each described an isolated sex act with the defendant that they now view as assaultive. The district court contends that the jury was free to see these specific indices as forced, quote, as forced labor. In light of other evidence it heard about defendants' conduct toward other women, but the government was not free to bootstrap testimony from other alleged victims to bolster their forced labor theories as to very specific acts charged in the indictment. Geronda and Faith were not living in a condition of servitude through threats of physical force. They each described a discrete act that at best might have been charged as some type of sexual assault, and even that seems unlikely. To construe these events as acts of forced labor would render the purpose of the statute meaningless and afford the federal government free rein to charge any sex act accompanied by harsh and unkind words as forced labor. 7. Defendant was denied a fair and impartial jury where several of the seated jurors admitted that the prejudged, Defendant was denied a fair and impartial jury where several of the seated jurors admitted that they prejudged the defendant's guilt, and trial counsel provided ineffective assistance of counsel when he failed to move to disqualify patently unqualified jurors. Okay. As United States Supreme Court Justice Black stated in Ray Michael 326, she cited the case, the Michael case, it is difficult to conceive of a more effective obstruction to the judicial process than a juror who has prejudged the case. That is because due process means a jury capable of willing to decide the case solely on evidence before it, and a trial court ever watchful to prevent prejudicial occurrences and to determine the effect of such occurrences when they happen. Then she cites the case Smith versus Phillips. The United States Court observed the right to a jury trial guarantees the criminal accused a fair trial by a panel of impartial and indifferent jurors. This is true, regardless of the heinousness of the crime charged, the apparent guilty of the offender, or the station in life which is occupied. A jury has formed an opinion cannot be impartial. That's right. In this case, the record shows that that at minimum 4 of the seated jurors, jurors 3, 4, 5, and 12, were not qualified to serve, and they let them sit their ass on there. This really pissing me off listening to this shit again. There were several other seated jurors who likely should have been struck for cause, but trial counsel failed to conduct any meaningful voir dire of these jurors to determine whether they could be put aside their expressed biases and prejudices. Trial counsel's performance was objectively unreasonable when he failed to move to disqualify patently unqualified jurors and failed to conduct any meaningful voir dire of prospective jurors who expressed their prejudgment of the case. Defendant was prejudged by his counsel's substandard performance, where it resulted in the seating of at least 4 seated jurors who were actually biased and could not act with impartiality. Then she stated the Strickland case versus Washington. Then she states the United States case versus Torres. Because of extraordinary pretrial publicity, the district court directed the parties to jointly prepare a juror questionnaire to probe, inter alia, prospective jurors' exposure to pretrial publicity. The court invited the parties to review the questionnaires in advance of jury selection and determine whether they could agree that certain individuals should be excluded for, quote, cause. After completing that process, the parties were left, what time is it? The parties were left with a set of potential jurors for oral voir dire procedures. The court gave both sides the opportunity to pose additional questions to prospective jurors. Inexplicably, defendant's counsel failed to challenge several jurors who ultimately sat on defendant's jury, who were plainly incapable of serving as fair and impartial. Juror number 4, revealed in the questionnaire. Go on, Jennifer. Question 39. The charge in this case involves allegations regarding exposure to one or more sexually transmitted diseases. Is there anything about such an allegation that you believe would affect your ability to serve as a fair and impartial juror? Answer: yes. I find transmitted of STDs in a non-consensual act to be partially repulsive. And this person had their ass on the damn juror. Are you serious? You got to be kidding me. Question 79. Which publicly known person do you least admire? Answer: Jeffrey Epstein. Although the court generally asked this juror whether anything she read would affect his or her ability to be fair and impartial in the case, and the juror replied, "Not that I know of," defense counsel failed to ask the court to question the juror whether his feelings of repulsion about the transmission of STDs in a non-consensual scenario would interfere with his or her ability to serve as fair and impartial jurors. A juror who expressly admitted that his or her feelings about the non-consensual transmission of STDs would affect his ability to fair and impartial should have been struck for cause out of the gate. You know that's right, Jennifer. Inexplicably, the juror was not challenged or even questioned about the repulsion. Isn't that some shit? For the precise act for which defendant was charged. This same juror named Jeffrey Epstein as accused pedophile as the person he least admires is yet further support that juror number 4 was not a juror who could serve impartially. Here we go. Juror number 5 disclosed the following in his or her questionnaire. Question 31. Have you watched or heard any interviews of Robert Kelly or any TV shows featuring him or any specials of documentaries about him? Answer, yes. Question, what were your general impressions? Answer, he loves underage girls. Ain't that a bitch? Question 32. From what you have, and this person was on the jury, I can't believe it. Question 32. From what you have seen or heard, do you have a general impression of defendant? Answer, somewhat negative. You know that defense team, they all should lose their damn law license. This is definitely unacceptable. That whole those people should lose they deliberately did this shit. I know damn well they knew better. They all took their ass to law school. That's some BS. This is truly sad. Question, why do you feel that way? Answer, the allegation that related he was sleeping with underage girls, minors. Although the court asked the prospective juror general questions about her ability to put aside other things she might have heard, when asked if she could be fair, the juror indicated that she would, quote, give it a shot. What? Are you serious? Oh my God, Robert, I am so sorry. This is just unacceptable. The court reminded the jurors that she had to be certain that she would consider only evidence offered at trial, and the juror begrudgingly what the hell is that? I know this word. Begrudgingly acquits. I can't even pronounce the fucking word. I'll spell it for you guys so you guys know what I'm trying to say. Begrudgingly, ACQUIESCED. I'll read it. ACQUIESCED. That's the word that for some reason I can't say the damn word. Even the district court expressed concern about juror number 5's ability to serve, observing, quote, so I don't know about you, but when someone says they think they can do something in this context, I don't think that's an unqualified assurance. And I don't know what the party's position is on that. I think I pushed her pretty hard on it, and we still ended up with, quote, I think so. Let me hear from the government if you have a position on that, end quote. Not surprisingly, the government was confident that the juror could be fair. Of course. Why wouldn't they? With that shit. The court still expressed doubts. Inexplicably, trial counsel agreed with the government, and the juror was sit. Oh my God. Them damn lawyers that was in New York, that's just terrible. Oh my God. Trial counsel's performance was objectively unreasonable, where he agreed to the seating of a juror number 5, who not only watched surviving R. Kelly, but concluded that defendant, quote, loves underage girls, end quote. There can be no trial strategy for failing to excuse this juror for cause. Had trial counsel challenged this juror, the court would have undeniably struck her for cause. Trial counsel not only failed to move to disqualify the juror, he did not even ask the court to probe more deeply into the juror's statements and the questionnaire that defendant, quote, loves underage girls, end quote, on her statement that she had, quote, negative feelings about the defendant because of allegations that he had engaged in with minors. Hey guys, I am so sorry. I have to pause this. I got to get ready. I am so sorry. You just don't know. But I'm coming back on immediately after my telephone conference. I got to prepare for this conference. Let me see if I can. Let me finish this. Let me finish this page, and then I'm gonna have to pause. I am so sorry, but we're almost done. But you guys didn't know this brief is over 100 is over 100 pages. So, and I didn't let you guys know that. So let me finish this page, and then I'm gonna have to come off of here, and I'll come back to finish it. I'm so sorry though, but I'm sure other people reading it. Okay. Juror number 3 provided the following information in the questionnaire. Question 29. The case for which you are summoned involved the defendant Robert Sylvester Kelly, also known as R. Kelly. Have you read, seen, or heard anything about the case, alleged crimes, or people involved? Answer. I watched the documentary, but I forgot the name of it. You're a damn. Now that tells you right there that person lied. Okay? Now you know damn well they lied. Oh my God. That's some shit. Question 30. Have you seen, read, or heard about Robert Kelly, also known as R. Kelly? Answer. Yes. Entertainer. I heard that he has been sleeping with underage girls. Question number 31. Have you watched or heard any interviews of Robert Kelly or any TV shows featuring him or any specials or documentaries about him? Yes. Question. What were your general impressions? Answer. I saw a documentary about him and his legal troubles. I don't know the full story, so I have no feelings and remain impartial. You a damn lie, and a damn lay person ain't gonna use no damn word impartial. So that's some bullshit. Okay? Come on now. Oh Lord, whatever. Trial, okay, so I'm gonna end it right there because this is gonna take me over to another page if I read this next paragraph. So I don't want to do that because I'm not going to be able to finish. I am so sorry, guys. I got to prepare for 11 o'clock telephone conference. We usually on there for about 30 minutes, maybe 45 minutes. So I'll say I'll be back on here. Even if you guys don't come and join me, I'm just going to come on and finish it, and whoever can catch it on replay. Trying to see. We're going to start at 11. We'll probably finish about 11:30, 11:45. I'll be back on at 12. How about that, guys, to finish it? I'm sorry. Please accept my apologies. Tamara, listening to you, I hop right on. I should have waited till tonight. But guys, kind of think about what I've already read so far so we could talk about it. I'm so sorry I have to split it up, but I'm almost done. So when I come back, I will be able to finish it. I didn't even let you guys know that the brief was over 100 pages. Okay. So I would talk to you guys, say at noon, come back and join your girl. Okay. Truly appreciate you guys coming over so early. Thank everyone in the chat. I know I didn't give you all a shout out. I'm ending on page 80, and I ended after that question where they were talking to the juror, and I'll pick up where it says trial counsel did not ask. That's where I'll be coming back at. So again, I stopped on page 80, guys, at the bottom. I'm starting with that paragraph at the end on the page. Okay, I'm sorry. Talk to you guys soon. Come on. Duty calls, duty calls, duty calls. I'm so sorry. But I thought I came on early enough that I would be done by now, you know? I'm sorry. See you guys shortly, though. 12 o'clock it is.